Oops, sorry, had the mic muted. Killed the intro. Kill it. Kill it. What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta. I am a lawyer in central Minnesota, and I am happy to be with you tonight because tonight we have the gift that kees on giving. Like the Jelly of the Month Club, it is unstoppable in its benevolence. You can see there's a little bit of change on the screen tonight. We have the chat will be a part of the video. It has been feeling left out, and I have been lost without it. I really quickly want to hit a super chat before it fades off of my radar. Adam Smith says, it is further ordered. You will pronounce it plaintiffses. And Kevin Fletcher says, Landau is, in my unactionable opinion, a cuck. And Alan Foster asks why my face is bald. Because I was eating some fried eggs today, and I like them runny, and they get in my mustache. Say Kevin Redacted when you talk about Boy Kev from Nicholas Redacted. All right, guys. Tilt the camera down a little. Okay, I'm. There we go. Is that better? Okay. All right. So, if you're not familiar with my channel, let me do a brief introduction. This is live, and most of you watching live will be familiar. Sarah Marie says, we feek is gay in Shiite. I don't even know how to pronounce those. If you're not familiar with this channel, what I do is I go through legal documents and I break them down one word or one apostrophe at a time, as it were. And this particular live stream, Chap666 says Landui, and yes, we are getting to Landui. Landui will be highly featured in this video. We will be going through the latest document in an ongoing lawsuit. The Rapture says almonds are a women. Lesson 125 says welcome to Lawsplaining the Interwebs, the show where the complaints are made up and the First Amendment doesn't matter. Oh man. This is the ongoing lawsuit between former lovers and co-hosts Maddox, George Azunian, and Dick Masterson or Dax Herrera. After a falling out, they have divorced, and the divorce got messy, and the kids are still up for grabs, although one parent seems to do a much better job of grabbing them than the other. So this latest Keck7Go says, shill the new TDS album. Guys, these super chats are coming in quick, and I will keep up, and I will definitely shill the new TDS album. But let me get through this real quick. This is the latest document drop. It is a plaintiff's memorandum of law in support of a motion for a temporary restraining order, protective order, and injunctive relief. Guys, I have to drop a quick spoiler. Maddox's lawyer, Kevin A. Landau of the Landau Group PC, is asking the New York court to exercise jurisdiction over the entire earth and stop everyone from mentioning his name or any information about him and his law firm that may be public. Denise E. says, for the Bike Boys of America, Nicholas Melchiori, the Landau Group, we reject reality and substitute our own. And that seems to be the order of the day, folks. Okay, so housekeeping. I do have a live chat. Like I said, the live chat is featured in the whatchamacallit? In the video here. You can see it right down below. I don't know why it says top chat. It should be live. My window says live. I don't know what's going on there. So maybe not all of the chats will show up, and I'm not sure how to fix that. But the majority will. here's the deal. If you want to ask me a question during this great live stream we have going, please drop it in this chat. If you tag me at Rekieta Law, I will see it. If you super chat, I will see it, and I will also love you. Here's What I Don't Get podcast asks, hey, at Rekieta Law, does Here's What I Don't Get count as affiliated with TDS? I think so. I think you're on the Catch You Next Tuesday network. Moderator, I know how to change it, and it does say live on my window, just not on the OBS window. So, not sure about how that will work. I will. Gabraham Sandwich says, won't love you if you don't super chat. No, I do. I love when people do super chats, but I don't require anyone to do a super chat. But if you do a super chat, I will see it right away. And because it puts as you can see, a big giant thing right in my chat window. Sarah Marie says she'll put at Tessa's mouth where my money is. So yes, the super chats are very visible to me. You do not have to do them. I love it when you do, but I will still read through. Windows 95 is not drunk enough to give me loads of money tonight, but I still love him or her depending on what day it is. Yes, absolutely. One other feature of this channel, if you're not familiar, is Whisky. And tonight, I'm opening with Hibiki Suntory Whiskey, Japanese Harmony. And it is, it's good. Good stuff. I'm very excited to dig into this. And I will be switching between whiskey and some less alcoholic stuff to pace myself, because this will probably be a 3-hour stream. So saddle in. The Rafter says, sorry for spling Imjin unironically being a dog bite lawyer. Imagine unironically being a dog bite lawyer. Dr. Cochter says, I love you too, Nick. And Spicy Tony says, hey, Jake, you're gay. Well, maybe Jake is. Alex Lashinsky says, the Landau Group PC is a carefully designed group of attorneys and advisors, researchers, and general support staff. Anthony says, Weefeek is gay AF, to be honest. Let's start getting into this. So, like I said, this is a memorandum in support of a motion for a temporary restraining order, protective order, and injunctive relief pursuant to CPLR 6313, General Business Law 349, 350, Civil Rights Law 50 to 51. Notice there is an immediate error of apostrophe still in the caption, still hasn't fixed it. Parker Anderson asks if Metal Jess could be involved in a slap lawsuit if that was to become a thing in this situation. Yes, she is a plaintiff to this action. Any plaintiff would be involved in any slap counter action that would occur, but New York is a hard state to do that. It's not impossible. It's just harder than California. As a lawyer, if you ever needed to avail yourself of some sort of legal defense, would you do it yourself or hire another lawyer? Alex Neves, that depends. Highly depends on the situation and the area of expertise and everything else. Eric Blum, do you think you're going to get sued for what people live chat? Maybe. Moderator says I should let him get it all out. Zarther asks, am I part of Dick's legal team? No. I'm not licensed in New York. I'm not licensed in California. I do not have any sort of financial relationship with Dick other than he is a patron of my show, just like many of you are patrons of my show. He does not pay me in exchange for legal advice, and I do not give him legal advice, much to the chagrin of people like Maddox and Landau. Chap666 says 6-hour live chat because this is funnier than Maddox. Sam Webb says Maddox lost. Anthony Tupin says Japanese whiskey, that's un-American. Don't worry, buddy. I'm moving to bourbon right after this. Here's What I Don't Get podcast says, hey, Rekieta Law, do your disclaimer. I don't have one. Here's my disclaimer. if you think a podcast or a video cast, a live stream of me making fun of some attorney for filing a bad document is legal advice, you need your head examined. Landau. Scotch companies are getting a lot more of my money since you started these, says Cuckucks. I know, and I really want them to recognize that and send me bottles. Goss Demon, a lawyer who represents himself as a fool for a client. That's a great idiom. It's true. Axiom? Idiom? We'll see. I thought Maddox was against nepotism. Why would he hire a lawyer who could only get a job through nepotism? And Eric Blum says, obviously you need a cumulative super chat counter. That is true. I don't know how to do that. Okay, guys. Unicorn Shape Building says, I officially endorse everything said in the live chat. I don't know. I've got to stop following the chat a little bit just to get into this document. Kevin Flesher says, still waiting for that Lagavulin sponsor. I am too, buddy. I would love that. They actually deleted that post. So if you guys want to see a Lagavulin sponsorship, maybe we should just bomb them again. Bomb them in the comments, not like ISIS. Alan Foster says Landau is a cuck, or so I've heard. All right. So the Landau group is the attorneys for Plaintiff C's, George Uzunian, and Jessica Blum. And they can't really decide if Jessica Blum should be anonymous or not, so she is not anonymous. Let's see. So here we have a table of contents, which I'm going to skip right through. Table of authorities cited, roll of the dice, and 5 out of 6 of these are probably incorrectly cited. Let's see how this goes. All right. So on to the document, and we're going to go full steam because not only do we have this 31-page masterpiece. Ferozan says, Nick, this is just for saying chagrin. Thanks, pal. Why do you put a paragraph in the table of contents? Okay, I will look at that because that could be interesting. So his subheading for Roman numeral 3 is a temporary restraining order or protective order against defendant Herrera, restraining him from making any extrajudicial statements about this case or about plaintiff's apostrophe or plaintiff C's or counsel for plaintiff C's or his law firm or referring to counsel for plaintiffs or posting any information, documents, or statements about him or plaintiff C's on any social media whatsoever is appropriate in this case, given defendant Herrera's defamatory statements, posting of private information of plaintiffs and their counsel, and other appalling retaliatory and vindictive conduct against plaintiff C's and their counsel. And then the next subheading, this is not a prior restraint. How is this not a prior restraint? With that lead-in, of course it's a prior restraint. Don't talk about us. But it's not a prior restraint. Smut Tiger says, support soy as an alternative to surgery. Yeah, I think so. All right, guys. So plaintiff's apostrophe George Uzunian, professionally known as Maddox, hereinafter Uzunian, and Jessica Blum, collectively plaintiffs through their attorneys, the Landau Group PC, respectfully submit this motion for protective order, temporary restraining order, and injunctive relief pursuant to CPLR 6313, Civil Rights Law 50 to 51, GBL 349 to 350 against defendant Dax Herrera. Preliminary statement. These are always good, right? This is the time where Landau takes a document that's not supposed to add new facts to a situation and adds a bunch of facts. In this case, it may be relevant. We'll give him a little bit of credit to add some facts to try and justify the impermissible suppression of speech. But let's see. As set forth in the attached affidavits. I love when he says as set forth, because you know it just isn't true. As set forth in the attached affidavits and the exhibits annexed thereto, there has unquestionably been violations. Okay. It's have. There have violations. Have been violations. Has been a violation. Have been violations. There has unquestionably been violations of civil rights law 50 to 51 by defendant Herrera against plaintiffs and their counsel that require court intervention and a temporary restraining order. No, there haven't. Thanks, Elijah Watson. There's no comment attached, but thank you, buddy. Subsequent to defendant Herrera being served in this matter, entering stipulations for time extensions, and then filing his pending motions to dismiss, Herrera has persisted with vindictive and hateful campaigns, threats, and other tortious and defamatory actions against plaintiff C's. See Landau affidavit at 7. The Landau affidavit, by the way, is 12 pages. And won't it be fun to watch a lawyer whine in his own lawsuit? However, such harassment and threats has now extended to plaintiff's lead counsel. They're plural. Have now extended to plaintiff's lead counsel, Kevin A. Landau, and his law firm, the Landau Group PC. What threats? What harassment? Who has contacted you ever? No one. Who has sent any sort of information to you? Like, we don't tag you in posts, don't do any, I'm not emailing you links to the video. We're not burning CDs of the video and mailing them to you. Like some sort of horrific cartel, mailing terrible videos to people. Adam Smith, amended order. It is further ordered. Nick will pronounce its plaintiff Sis as it was meant to be in the possessive form. I want to know how anyone has threatened or harassed you, Mr. Landau. Mr. Landau. This has manifest in defendant Herrera's defamatory statements against counsel for plaintiffs. That should be good. Let's see if he knows what defamation is yet. And threatening to release private information of an attorney in this case. Is it private information if it's public record? To his fans as content for his show and solely because he represents the plaintiffs. How do you substantiate that that's solely because he represents the plaintiffs? When the foregoing came to Mr. Landau's attention, 2 separate letters were drafted and electronically mailed to Miss Matz Esquire, counsel for defendant Herrera. The second letter contained a cease and desist, which demanded defendant Herrera's compliance. We demand your compliance by on or before February 10th, 2018 at 3 p.m. Eastern Time. However, the documents, slurs, encouragements of fan outbursts, and overall intimidation techniques against Mr. Landau remain at the time of this affirmation submission. They remain at the time of this affirmation submission. Okay. Immortal Thor, can we start a fund to send Landau hooked on phonics? Oh, that would be brutal. That would be brutal. I don't know if we should do that. I don't want to send him anything. See, this, I'm going to get to this point, but like, what threats and intimidation? Does he think we want him off the case? I wouldn't. If he tried to get off this case, I might, like, if Maddox ran out of money at this point, we should pitch in and keep him hired. Alkembra says, thank Landog for the Scooby snacks or your mother will be sued in her sleep tonight. All right. So, point of legal precision here. A cease and desist has no force of law other than to act as serve as notice, right? It's notice that we don't like what you're doing. It doesn't mean you actually have to stop. It doesn't mean you actually have to do anything. You can persist, but if you persist in doing what they ask you not to do, then, it typically sets the groundwork we will consider legal action or whatever. That doesn't mean what you're doing is illegal, and it doesn't mean because you sent that cease and desist that there's any teeth to it, right? Like a dog bite without teeth. Kevin Flesher, is it harassment to send Landau a 3rd grade English textbook? That's a good question. That's a very good question. I don't know if I should answer that one. I can't give you legal advice on what that would be, but I can't see how it would be harassment unless there was something awful written in the English textbook. But let me be clear, guys. Like, let's not send anything to this guy. There's no reason to do that. I get the feeling that he's getting the messages just fine. So Sukatsu Clone says, take the L in Words with Friends. You can never beat me there. The Lawsplains. How many times will they go back and forth before this gets to court? Yeah, I will take the loss if you're who I'm thinking of, because you handed me my derriere. This hopefully will never get to court. And I say hopefully to my own detriment, because the longer this goes on, the better I do. But hopefully for the people involved, like, Dick Asterios and Mad Cucks and Bozer and Foundation Digital and even Patreon and Weber Shandwick, this needs to drop. Like, it needs to go away. So it should never get to court in any tangible way. It should be dismissed based on the motion practice. But if it succeeds motion practice, we shouldn't see too much more back and forth before we start getting some hearings. Hatbuckles, has a licensed attorney ever been sanctioned for exclusively using freely available MS Word templates for their filings and not even proofreading? I don't know if that's true. I don't know if it's been that way, or I don't know if anyone's been sanctioned for that, and I'm not 100% sure that this has happened, but it kind of maybe looks like it. Smut Tiger says, Landau touched me in my funny bone. All right. Okay. So inclusive with Mr. Landau's cease and desist notice were over 50 pages of content that Herrera has created and engaged in since November 14th, set forth more fully below, and date of service of the complaint. Yeah, you read that right, guys. They have compiled 50 pages of bants and handed it to us. And we're not going to go through that at all. So Alex Neve says, while we all had low expectations for Maddox's writing ability, one would think a lawyer would not make so many mistakes as a professional. Shame. I agree. It is a shame. And a serious point about the apostrophes. Having a comma or an apostrophe in the wrong place can cost millions of dollars. It can cost you a case. The Raptor says, buy that girl some OJ. She got OJ at the last stream. She got OJ today. She is ensconced in OJ. Ubercube, hi Maddox and Landau, how are your Fridays going? I don't think well. This includes, but is not limited to, defamation, invasion of privacy, constant harassment, posting of private information, intimidation, retaliation, slanderous comments and offensive references, inciting and encouraging Herrera's fans to troll, insult, and demean, numerous defamatory, racist, and threatening posts and messages, including targeting plaintiff's counsel and posting multiple defamatory statements and threatening and actually posting private information and documents of counsel for plaintiffs designed to humiliate, retaliate, and damage his reputation, interfere with his relationship with his clients, the court, and this underlying lawsuit. Nope. Anthony, I gotta head to bed now. Just remember, We Feek is gay. I will not forget. Have a good nap, buddy. Let's see. Sorry. Reading the comments here. What's the big deal? He didn't even mention that he suffered unimaginable pain and suffering. Right. Without that unimaginable pain and suffering, he has no claim. Al Kember says, this message is purely here to annoy Tess, who's getting frustrated by Nick stopping to read all the super chats. Despite these letters and over 50 pages of defamatory and harassing content made by Herrera and sent to his counsel, Miss Matz, Herrera has not stopped his harassment against plaintiffs or their counsel, nor taken any content down. It is apparent the defendant is not heeding the advice of his counsel. Consequently, the court must now intervene and restrain defendant Herrera from this abhorrent conduct immediately. So what that individual is saying is Landau touched him. So guys, I think now is a good time to take a step away from the document. IT Weeb says, so what that individual is saying is Landau touched him. That might be. these are the letters. They've included them as exhibits, and let's examine them to get kind of a frame of reference for what we're doing here. So, Dear Sarah, to Sarah Matz, and this is from Kevin. I understand you and Zach, I believe, is Kevin's brother, Zach Landau, another managing partner at the Landau Group, spoke earlier concerning the ongoing attacks levied by Mr. Herrera against Mr. Uzuni and Miss Blum and our law firm. Really? Our office is compiling upwards of 60 pages since the beginning of litigation. We'll be sending to you shortly. In advance of such correspondence and out of professional courtesy, I am respectfully requesting that you have a conversation with said individual to cease such conduct forthwith. All posting of private information, slanderous references, insults and encouragement intended to demean. So, like, are we not supposed to say, go get him, buddy, if that's demeaning, I guess? Must be promptly removed. Please advise him that failure to do so will require us to seek the assistance of law enforcement, as well as pursuing parallel civil remedies. Dominic Peluso says Michael Malice is the key to all this. Oh, man. Snake, that is depressing. Snake Jerusalem says both you and Maddox are live now. You have 450 viewers. He has 170. Man, I wish I could get, every time someone clicked an unsubscribe button from Maddox, I wish I could get them, like, redirected immediately to my page. We will afford your clients the weekend to comply. However, come Monday morning, all legal recourse against such hateful behavior will commence. Thank you for your immediate attention, and my apologies, this matter is time critical, requiring your involvement on a Friday afternoon. Feel free to contact me directly should you have any questions. Here is the other letter, dated the same day. Patrick Lonergan says he likes this layout better, but missed the guy with the hat on him. He's off frame. Maybe I'll feature him near the end of the video. So, Dear Sarah, there are a few additional documents and comments uploaded to Mr. Herrera's Twitter account that were excluded from the voluminous package Zach sent separately, but voluminous package. Zach sent separately, but enclosed for your convenience. The sole purpose of such posts are to harass, defame, and intimidate. Nope. The latter is not working. However, the former is going to compound his legal battle. Okay, guys. If you're not intimidating someone and they send you a letter, to prove that they're not intimidated, sounds like a lie to me, but, maybe. The latter is not working. However, the former is going to compound his legal battle, expense, and ultimate financial exposure. Keck7Go says thedickshow.bandcamp.com. Yes, as soon as I get done with this letter, I will focus on that. Whatever 3241 says, is there any strategic value to doing one of these motions? Also, heart. There is strategic value, and we'll talk about that in a minute. Yes. Yes, long and short, yes. Smut Tiger, Landau called me gay in a dream once. Were you mad at him afterwards? That's the real question. Are you mad at people for your dreams? Let's see. Please advise your client that if he does not cease and desist, including the removal of all posts and retweets by 12 p.m. Pacific time, Saturday, February 10th, 2018, from any further display or reference to myself or our law firm, and continues with such civil torts and possible criminal acts, I will file an injunction and lawsuit against him personally, along with all others complicit in such behavior. So you should all expect a lawsuit, I guess. Alan Foster says, voluminous package. I've finally been named in this lawsuit. I will hold Mr. Herrera responsible in the event his followers or associates decide to continue with such activity. Sorry, Dick. As attorneys, our obligation is to advocate on behalf of our clients. That is our job. I'm attempting to do mine. I mean, you say that, but a review of the record might indicate otherwise. The same as you are doing yours. From the commencement of this lawsuit, he misspelled it. It's supposed to be LoLsuit. I have made it very clear that with my client that there is to be zero objectionable communications regarding the defendants. Well, why? Why? He's an entertainer. Why would you do that? Chap666, lick that smash button. Internet Tab says, bring it, Landau. He fortunately listened and has strictly adhered. Why? Like, his defamation already occurred. He defamed Dick a year ago. I trust you will do the same and gain control of your client before this litigation reaches an unnecessary precipice. Look, guys, just speaking from personal experience, the idea that you control a client is nonsense. Nonsense that you have any control over what they do. You can beg and plead for them to listen to you, but as a criminal defense attorney, I beg with every person I meet, not just clients, but everybody, please don't ever talk to the police. And they do every time. Denise E says everything is a contest. Who gets screenshot on Landau's lawsuit? Hashtag roof. We'll find out. We have always been polite and professional with one another, even when we have disagreed. It's part of being lawyers. I trust you will exert the effort necessary to quash this matter forthwith. Who says forthwith? Like, I know you got a law degree, but come on. I am confident this is a path no one would like to be compelled to pursue. You're not. Particularly your client. Thank you again for your attention and anticipated cooperation. So there are the letters, and I wanted to get those out there to let you know. First of all, as far as like cease and desist go, not great. I don't know. I would have been a little more forceful. I would probably, personally, I would cite statutes that they're in danger of violating. I would talk about, I would talk about common law issues. I might cite case law, something. You're writing this to another lawyer. Just like in a motion, tell the other lawyer why you're right, because they're going to immediately think that you're wrong. At least I do. Some kind of taco says, sometimes I wonder if these guys' egos are so big they honestly think they know better than the autocorrect. I know mine is. My autocorrect on my phone makes me want to punch everything. Someone earlier, I can't pronounce your name, FFJ Bur2, asked what my IQ was. I have no idea. Sufficient. How's that? Let's see. Okay, so despite these letters and the over 50 pages of defamatory and harassing content made by Herrera and sent to his counsel, Miss Matz, Herrera has not stopped his harassment against plaintiffs' apostrophe or their counsel, nor taken any content down. And I'm going to get to the Bandcamp thing. It is apparent that defendant is not heeding the advice of his counsel. Consequently, the court must now intervene and restrain defendant Herrera from this abhorrent conduct immediately. So if you don't know, an album just dropped. It's the Dick Show album. You can get it at dickshow.bandcamp.com or bandcamp.dickshow.com. One of those two, whichever one is correct. It's like $12. Pick it up, guys. It's great stuff. Dick's fans are shockingly talented. The beats are really good. If you like any sort of electronic music, you'll be into it right away. Although I make no expressions, warranties express or implied, and I do not have any sort of financial interest in that. I just want to see it succeed because those guys worked really hard on it, and it's great stuff. Smut Tiger, Landau has likely touched a child with his hand. Well, I don't know if that's true, but maybe. I mean, I guess that's a reasonable inference. Statement of applicable facts. Actions taken by Herrera against plaintiffs subsequent to the instant lawsuit being filed. Plaintiff's apostrophe. Let's not forget it. You're welcome, Vistas. Seriously, I haven't listened to the whole thing yet, but it's great. Like, everything I listened to was good. And I'll throw, once this video uploads, I will throw a link in the description. So make sure you pop back in and check the description and then go to it for the Bandcamp link. All right. On January 27th, 2018, Herrera posted a picture of himself purchasing guns and ammunitions with the caption, "Picking up some anti-Maddox protection." This image was posted on Instagram, Facebook, and Reddit, and is clearly an intimidation tactic. How? How would that possibly be an intimidation tactic? I'm going to protect myself from an unhinged person is not an intimidation tactic. He did not say, I'm going to go blow up Maddox with my cool, sweet guns. Okay? That would maybe be intimidation, although likely not, because he posted it on Instagram, which means it does not fall under the auspices of an imminent threat, and therefore is hard to be any sort of threatening statement. Oh, Monster Slayer wants to remind me that the Dick Show album is also available on Google Play and iTunes. And Alex Neve says, since the Dick Show album is recorded audio, it would be slanderous, not defamatory. Defamatory is the catch-all phrase. Slander would be audible, and libel would be written, published written stuff. Dr. Richard R. Ape says, to Rekieta Law, can I sue Landau for saying I abbreviate to Dick Rape? The R in my name is silent. I think so. The term instant is used multiple times. Is this a specific legal term? Yes. In a legal document, instant simply means present. The instant case means the present case, because usually you're going to be citing a bunch of other cases, and the instant case means this one. This one, not some other citation, not some other reference. So hope that clears that up for you. This image was posted on Instagram, Facebook, and Reddit, and is clearly an intimidation tactic. In response to a fan, Herrera states that he ran this post by his lawyers, and they told him not to post it. So what? On February 2nd, 2018, Herrera made another post holding a loaded assault rifle and wearing a t-shirt with whales on it, acknowledging it as a reference to Mr. Azunian's book. Herrera's fans are now openly suggesting he used violence at Azunian. He attempts to back that up. Landau affidavit at 14. We'll check that out later. Seems to me like you might be, at best, suggesting violence against George's book, which would mean someone would have to buy it. You'd have to buy the book to shoot the book, and that would be more sales than Maddox got for the rest of the week. On or about January 31st, 2018, Herrera made a post and harassed Mr. Azunian. There is some coarse language coming up from Landau, by the way. Not from me, and interestingly, not from Dick. So let's be real clear that Kevin Landau is the person who drops the upcoming F word. Dick does not say the upcoming F word, nor do I. Well, I mean, I read it. So here we go. On or about January 31st, Herrera made a post and harassed Mr. Azunian by referring to him as a soy boy. Dick Masterson referred to Maddox as a soy boy, which is a slur used similar to cuckold and faggot, which comes from Kevin Landau. Let's be clear, because what Landau is trying to do is use word association to trick the judge into thinking that Dick said something worse than soy boy. So, just so we're all aware that it is Mr. Landau who used that phrase, that hateful homophobic phrase. I think we can maybe infer that Landau has issues with that. It was meant to emasculate Mr. Azunian. It's hard to do at this point. He's already low on the totem pole. Since people who eat soy... Guys, since people who eat soy have higher levels of estrogen and are women... I apologize. I apologize for laughing really loudly into the microphone there. But 10 p.m. Agenda says, don't waste reading the affirmation. It's a carbon copy of the memorandum of law. Thanks for letting me know that. We'll probably just skim it real quick and see if there's anything juicy in there. So just so you know, if you eat soy, you have high levels of estrogen and are a woman. He posted this to also, and again, that's from Landau. Landau has decided that people who eat soy have higher levels of estrogen and are women. He posted this to also promote his own show and channel when people click on his name. So, Dominic Peluso says there's nothing inherently wrong with soy boys. Windows 95. Wait, all I needed to do was eat soy. Yeah, you could have saved yourself a lot of trouble. In a subsequent post made by Dr. Richard R. Ape, the R is silent. Which R? First R or second R? Dr. Richard R. Ape, which abbreviates to Dick Rape, apparently. It doesn't, though. because the R is a separate word than the last letter. Kevin Flesher, anyone who has ever eaten soy has high levels of estrogen and are women. Thank goodness I've never eaten soy in my life. Nicholas Melchiori, the Landau Group, citations needed. At Sharky, I don't know what the scientific consensus on soy's impact in testosterone and estrogen is. If I understand right, the scientific community does not support that position. But I don't know, and I am happy to be wrong in either way. I don't actually know. But IT Weeb, I'm not going to give him that much credit in saying that it implies that. No, this is a legal document. Be precise, because if you're not precise, you lose. Okay. Let's go. Which abbreviates to dick rape, which I don't think is actually true. Dr. Ape, at least he respected your honorific, claims that Mr. Azunian caught genital herpes from Miss Blum and that she had sex with other men regularly in front of him. Did Dick do this? Did Dick Masterson do this? Spicy Tony says Christian Halbert is a cuck and needs to leave. Sweet. Chap666 says Maddox looks like a victim of the Armenian genocide. And Tanu Bojangles says, I love how Landau goes on to abbreviate Dr. Richard R. Ape as Dr. Ape. Me too. All right. So yeah, Dick didn't do it. Dick did not post that, unless you're trying to say that Dr. Richard R. Ape is Dick Masterson. Let's see. On February 2nd, 2018, Herrera posted a picture of Mr. Azunian on his official Facebook page, further attacking his image. Like, what does attacking an image even look like? Was Dick stabbing a photo? And suggested that he is autistic and attacking autistic people in general as how... Whoa. Big foul, buddy. I don't think that he was attacking autistic people at all. As the temple of Grandin's hug machine is a blanket that's used to comfort autistic people. How is that attacking autistic people? Otaru says, I like how Dr. Ape has an apostrophe after it. He does, but what he's weirdly, he's got an apostrophe before it. So what he's trying to do is like a quote that you would do within a quote, like a subservient quote inside a quote, but it's not inside a quote. So he's just wrong, like normal. He doesn't know. He just doesn't know. On December 31st, 2018, Herrera made a post and called Mr. Azunian mentally deranged. So, that's not illegal, you dummy. On December 5th, 2017, Herrera commented on a popular picture. On December 31st, 2018, Dick is in the future. Good job, Dick. Time traveling to make that post. You better set a reminder for New Year's Day to call Maddox mentally deranged. You better do that. Okay. So on December 5th, 2017, Herrera commented on a popular picture of Burt Madcucks and said it was actually Mr. Azunian to create brand confusion. Yes, this is Maddox. I mean... The audacity of these people. On January 7th and 11th, 2018, respectively, Herrera engaged in targeted harassment on this official internet relay chat server. One of his fans wrote the following on January 11th. Guys, can you read this? Gad the Rad says, everybody needs to call Maddox right now. His number is 310-867-5309. Targeted harassment campaign. Keck7Go says, Landui, the time-traveling attorney at law. On January 11th, 2018, at Details says, anyway, how about that Maddox guy, huh? At ACIOU says, he's the kind of guy that really makes me want to organize a targeted harassment campaign. Mr. Landau. Wanting to organize a targeted harassment campaign is not actually organizing a targeted harassment campaign, and even if it were, you have already established that Dick's name in the IRC is Peen Wienerstein, not ACIOU. No. Oh, apparently you guys think that I am missing. I haven't been following the chat as closely as my off-screen assistant. You think I'm missing the joke of Landui, as I'm pronouncing it that way. It's Landui. Yes, it is a reference to his multiple DUIs, which will probably be a feature of some upcoming goss from somewhere. I don't know where from. Maybe from me. We'll see. Kevin Cartilage asks, is DOGBITE using apostrophes wrong out of spite at this point? I have wondered the same thing. Perhaps. Demesian says it's Temple Grandin, not Temple of Grandin. Temple of Grandin is probably like a Zelda level, right? Thanks, Unicorn Shape Building. I'm working on it. Kevin Flesher says, hello, Nick's off-screen chat viewer. Zarther, thanks. These are the Norland whiskey glasses. I really like them. The extra glass around the outside, allows you to hold it without heating up the whiskey. So it's really good. And Keck, my wife thinks I'm that oblivious because I usually am. On November 15th, 2017, someone impersonating Mr. Azunian made rape threats to Miss Blum on her YouTube channel and claimed that she gave Mr. Azunian herpes and stated other disgusting and vile things. And oh my goodness, guys, I just noticed this. Look at this. Every paragraph Landau starts is O, 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 O. Landau is clearly structured this document to say, ooh, as if he's got dick. He has clearly set up this paragraph structure to burn dick in this document. And I think that is a little bit out of the rules of decorum. Shame on you, Landau. That is not okay. On December 8th, 2017, someone on Herrera's subreddit created an account impersonating Mr. Azunian. He dug up old divorce records of Azunians and shared them online for the sole purpose to harass and humiliate. Do you know how he dug them up? Like, he just did a Google search. Alex Lashinsky says, please say orangutan instead of Azunian from here on out. I will try. My brain doesn't always edit on the fly that well, but I'm going to go for it. If not, just yell at me. David Bird, I absolutely want some Japanese whiskey. How do I message you? Do I message you on here, on YouTube? Or send me a message on YouTube and I can respond, or message me on Facebook? I don't know what you guys are talking about with cuck and LoLsuit and apostrophe, by the way. Let's see. Okay. On December 23rd, 2017, defendant Bert Madcuck stated on Reddit that he's buying Mr. Azunian's book to intentionally leave a fake negative review. Did he say it would be fake? Or did he just say he'd leave a negative review as a verified buyer? That doesn't make it fake. Nicholas King, every time we make a sarcastic comment, Landau charges Maddox. Oh, Zarther says, got to throw in some money for answering my other questions. Tess is great, by the way. I agree, she is. And I did just assume her gender. On January 8th, 2018, Herrera's fans on Facebook ran a brute force intrusion attack. Guys. Okay, to scrape all the directories and files from Mr. Azunian's web server. Okay, so if you are not a technology, and I am not a technology, I'm okay with being a technology, but I am not a superstar. I was on the IRC today, and many of those guys are much better versed in this than me. And I asked them about this brute force attack, because I was under the impression that someone did not do any sort of sophisticated hack of Maddox's system. And it turns out that's true. No one did any sort of Orangutan. Sorry, I'm going to get it. What someone did was they typed in maddox.xmission.com / and then added words. They just added words and tried to see what would happen, which there's some dispute, but I think the overall consensus in the IRC is that it falls under the basic definition of a brute force intrusion. However, it is not, as implied, some sort of illegal or hack material. No passwords were violated. There was not a script running this thing. It was just some guy who admittedly got drunk and started typing things in. And Rise and Fall of Maddox the Loser, yes, hack the planet! Hack the planet! This is garbage! It's garbage! Okay. So they found some private images of an acquaintance of orangutans, as well as a file containing passwords and private server information. Let's be clear, that password and private server information did not belong to Maddox. It belonged to Dick. Finding it was an interesting revelation, and it was under /Dax. So Maddox even knew it belonged to Dick. Keck7Go says 500 Rekieta Law versus 240 Maddox. Maddox lost. Absolutely. And will continue to do so over and over again. File containing passwords and private server information, which again did not belong to Maddox. Good job. Good job including evidence of your client's potential conversion or theft in your document. Great representation there. The IP address is listed in Exhibit 15 tried accessing Mr. Orangutan's private files from Herrera's subreddit. Herrera's fans started showing the picture of his acquaintance above. They were asking who this was because it was a little creepy for Maddox to have a webcam picture of a girl's face just floating around on his website. And over 1,266 requests have been logged from an IP address linking to this file from the Dick Show Facebook group, as well as Herrera's subreddit. Maddox is simply intimidated by this because he doesn't know what an active community looks like, and this is an active community. His community could never muster 1,266 of anything. Where they achieved the stolen image annexed here too. The IP address was 178.79.138.22 li194-22.members.linnode.com. This server, linnode.com, is one Herrera has used in the past to host assets for Plaintiff Orangutan's old show. I guess Dick is the only person who uses that server and is likely linked to Herrera himself. Proof needed. Proof needed. You can't just likely link something to someone. Show how it's linked to them. Or Defendant Foundation Digital. Yeah, because that Foundation Digital was using their secret algorithms to hack Maddox's website. Metasploiter says the tools Dirbuster, Derb, or GoBuster will search a website structure. These are completely legal to use and not brute force attacks. A brute force attacks would use Hydra, etc. All right. Shout out to Scott Severin, one of Herrera's fans. Scott Severin messaged the picture to Mr. Azunian to intimidate and harass him. Good job, buddy. Okay, guys, says congrats on making more money in one night than Maddox makes in a month. Also, I recommend the Glenmorangie La Santa to both you and Landau. Wait a minute. Why would you recommend it to Landau? But I will give it a look. I had the Glenmorangie 10. I wasn't a big fan. But that's just, that doesn't mean anything to me. I'd love to try the La Santa. I'll take your recommendation and run with it. That's a confession. Nick is part of the legal team and confessed sucking. All right. Mr. Azunian had started creating an IP block. Mr. Orangutan has started creating an IP block on any request for his private data from his subreddit. However, Herrera and his fans have decided to continue interfering with Mr. Orangutan. How are they interfering with him? By going on public access locations like libraries, coffee shops, and even camping outside his house to make him block more people than intended. I don't think that anyone actually did that. It was a joke. I gotta have the Lafreg 18, similar to Lagavulin 16 in some ways. Eric Blum, I will find some. They don't have any in my town. They don't have the 18 Lafreg, but I will look for it. Gargle Buckets, Landau needs all the scotch. And I'm, Fahukal Gods, I don't know who Uzunian is. It's orangutan. And I'm having pronunciation troubles, probably from the liquor. Okay. One of his fans even suggested going to Mr. Orangutan's house and coffee shops he frequents to get him to ban his own IP addresses. First of all, you just said they did that, and now you're saying a fan suggested that. The latter is the appropriate one. It's the joke. Martial Autist, who is frequently on these streams, I believe. If anyone lives near him, just go to the Wi-Fi hotspots in places he normally goes and follow the link from there. Too bad you couldn't get within his own router. By the way, too bad you couldn't get within his own router is not a suggestion to go to his house. All right, on January 25th, 2018, defendant Burt Magcucks read a letter to Mr. Uzunian, wrote to his ex-girlfriend that she found and provided to Herrera. I think he actually did that on, wasn't it December 2nd in Chicago? Herrera teased this letter for months on his podcast and charged money for people to hear it read at his live show in Chicago on December 2nd, 2017. No, he charged money for people to attend the live show, and that was a part of the live show. The otherwise 2-hour-long show, which featured several entertaining bits of comedy. Also, there's nothing illegal about that because the letter was owned by someone who gave Mr. Herrera permission to use it. Tilt the camera down more? But if I only focus on Super Chats, moderator, then how would I see the message to tilt the camera down more? Oban 14 is great. I will agree. I haven't had the 12. On December 5th, 2017, several of Herrera's fans spammed the following comment on Mr. Uzunian's videos on YouTube. Hey, just letting you know in case you weren't aware that Maddox is a scumbag who is suing people for calling him names and censoring any mention of the lawsuit from any and all of his social media pages. As a listener of his, I feel you deserve to be informed. Not dick. Not illegal. Thanks, Adam. On November 14th, 2017... Herrera emailed Mr. Orangutan, his friend and colleague Michael Malice, and his book editor Jeremy Ruby Strauss as soon as he was served on November 14th, 2017 with the summons and complaint. He did this to humiliate... Actually, I think he waited about an hour and a half, if I got those times right. He did this to humiliate Mr. Orangutan and to strain his relationship with Mr. Ruby Strauss. He has a contractual relationship with Ruby Strauss. And by the way, if we take it that Maddox wrote the complaint as sort of indicated in the email, that would be a promotion because the complaint was funnier than Maddox's book, Fasterisk Whales. Thanks, Chris Howell. And Kmart says $5 for cleavage. I don't know what kind of quality you're going to get for $5. On December 28th, 2018, Nick Rekieta. Hey, that's me, a lawyer and friend of Herrera's. Oh, hey, Dax. How's it going, buddy? We're friends now. I don't know if we're friends or if we're counsel, or if I'm counsel for you. We'll find out. Who appears on his show and has been creating hours of analysis of this lawsuit. So many hours. Personally harassed Mr. Uzunian on his YouTube channel with several comments. Here's one such comment, also attacking one of Mr. Orangutan's sponsors, HelloFresh. Let's be clear. Oh, yes, and let me point out that I haven't done this yet, but I did this on December 28th, 2018. The problem is I don't know if Maddox will have a YouTube channel by that time. But I will set a reminder and make sure I do it again. Let's see. If you guys can see this, they only included one of my quotes here. And so it says Nick Rekieta because they screen capped it right away. And that was before I actually, guys, this was before I changed my YouTube name to Rekieta Law. That's how early they were doing this. they were screen capping this before I had changed the name of my YouTube channel to Rekieta Law. So here's what I actually wrote, because I wrote 2 subsequent comments, and this is on his Arby's video if you want to go see them in the wild. So when do you address the overt associational juxtaposition that occurs in your HelloFresh ads on Madcast, or every single picture of you with a co-host of another podcast or show? Is your next show going to be called Biggest Hypocrite in the Universe? Because Maddox was complaining that Arby's was using associational juxtaposition, and his source material, by the way, was a grad student with no writing credentials at all. And then my next comment was, why was the voiceover done by a slovenly dressed, slow, dim-witted individual with a speech impediment common to people with Down syndrome and characteristic of a person with disabilities? Also, you should pretend you haven't watched my analysis of your lawsuit and watch it again. So that's what I actually wrote, which I think is a much more complete version than what they included here. And, you know, reading my own comment again is harassment. I agree. It probably is. It is unclear if Mr. Rekieta is associated with Herrera's defense team. Like, of course I'm not associated with Mr. Herrera's defense team. If I was, I wouldn't be making money on Patreon and YouTube. I'd be making money from Dick himself, straight from the horse's mouth. However, he has since appeared on Herrera's podcast. Yeah. And I would love to do that and will love to do that in the future, hopefully, if Dick will have me back. And has created his own U-Space-Tube channel. He got it right. It's a channel, guys. We need to give him credit and do some classical conditioning and encourage him when he does it right. It's a YouTube, I mean, half right. He gets half a point for channel, but he gets minus a half point for the space between you and tube. Arbin Gordon, the Google suit, I don't know, was the Google suit actually dropped, or was it just the NLRB issued their memo? That's 2 different things, and I'll talk about it in a different video. Don't distract me. How dare you? Solely to provide negative commentary about it and plaintiff's counsel. That is not true. I created this YouTube channel 6 years ago, and I have uploaded numerous videos about Eternal Crusade, the Warhammer 40k third-person shooter MMO, and I played the beta of that. And I have also uploaded numerous Diablo 3 speedruns, which are pretty sweet and you should check out. And that is why I created the channel, actually. So it is not solely to provide negative commentary about this case and Kevin Landau. It is actually for many other things, including commenting on the ongoing Google lawsuit, or maybe the dropped Google lawsuit if I'm behind the times, as well as other legal topics and presidential executive authority and constitutional issues. Please check out my other videos. The one I made last night, I am particularly proud of. I thought it was great. You guys may disagree, but please don't. Patrick Hosseini says, I'm from the future. Stop this stream. The fate of the world depends on it. All right. James calls me a nerd. This is true. Follower of Nurgle. Blood for the blood god, buddy. Yes, I do play Grim Dawn. Friend me on Steam. Send me a message. Okay. On December 27th, 2018, defendant Bert Madcucks teleports to the future and comments on Mr. Orangutan's YouTube video several times and calls him a effing retard. Alkembra says, don't stop the stream, no fate but what we make. On January 16th, 2018, on episode 85 of his podcast, Herrera attacked his own lawyer and demeaned her for being a female attorney. It's a joke. Google lawsuit any percent. Whatever 3241. Yes. And Graham Laws says skulls for the skull throne. That's right, buddy. Herrera says, Dick Masterson says, so I shot an email off to my attorney who is a woman because that's how little I respect Maddox's lawsuit. She listened to the show too. Look, if I was getting sued for something I did, I'd get a man to defend me, obviously. Someone does not know what is an satire. Adam Smith, thanks, man. He says, my video yesterday was profound and deserves a much larger audience. I appreciate that greatly. I'm hoping that those videos that are not this will get the attention the same type of attention that these get. I won't say that they deserve, but they will get the same type of attention that these get because I do put a lot of work into them. And, I like to engage in the conversation. On January 2nd, 2018, as indicated above, Herrera has indicated in multiple posts and in his podcast that he has consulted with his defense counsel about said posts and that she was aware of them and has listened to his show. Again, so. On January 2nd, 2018, on episode 83 of Herrera's podcast, he read private chat transcripts. They're not private. Facebook owns them, and so does the other person. That a fan named Isaias Lozano, a.k.a. Waterboy, congrats for making it, buddy. By the way, love your work on the album. And your work throughout the year, of course, not just on the album. Leaked to him. He puts leaked in quotes because they were like he's not even sure if they were actually leaked. Lozano had posed as a curious and sympathetic fan friend to Mr. Orangutan. I don't know if he posed as a curious and sympathetic fan friend to Mr. Orangutan. I think he was until he saw just what a horrible pile of trash Mr. Orangutan is, only to turn around and share his private conversations had over Facebook that are scanned for algorithms. Did you know that the algorithms scan your private conversations, by the way? Try posting something lewd in there, including mental health issues his family had dealt with, Miss Blum's mom's surgery, and other private details with Herrera. Herrera read these comments for the sole purposes to humiliate, harass, and profit from. You can't have sole purposes, right? You have a sole purpose. If you have a sole thing, it's just one. If you have more than one, it's not sole. Okay? Since Mr. Herrera charges for such content as depicted on his January 2nd, 2018 show, episode 83, available for free at dick.show. Relevant transcripts from his show are included. Since he charges for his free content that you can just get right now for free, Herrera is trying to incite his fans. He understands that by getting his fans to invest themselves in a bet, some may be motivated to act out against Maddox to win. This is the second time he's announced a death pool. Liar, 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 liar. Dick did not announce the death pool the first or the second time. It was SG Dove on Twitter. SG Dove on Twitter is the guy who announced the death pool. Don't you dare take that away from him, and don't put it on Dick's shoulders. He didn't do it. President of Saw says, I didn't know about you before joining the Dick Show Facebook group, but I'm glad I subbed. These streams are amazing. Thanks, buddy. I'm glad you subbed too. And I love doing these streams. Alan Foster here have soul dollars, and he gave me $2. I'm glad that Landau misunderstands that. All right, this fits the pattern of his interference into Mr. Orangutan's private life and affairs by publicly rewarding Lozano for his leaks. How did he publicly reward Lozano for his leaks and betrayal and encouraging other fans with dirt on Maddox to provide it to Herrera with more leaks if possible? How did he reward him anything? Reddit, yes. What did I say? I meant Reddit. Yes, Reddit. James says, I mean Reddit. Yes. SG Dove on Reddit. Did I say something else? Did I say Facebook? Sorry. But the death pool is on Reddit. Go check out the death pool on Reddit, by the way, and cast your bets for when the Madcast Media Network will tank. On January 25th, 2018, Otaru says, real quick, Dick has mentioned the death pool on the cast, but did not create it. Gotcha. But again, he's referencing someone else's work, not his own. And Landau has this uncanny habit of attributing things that other people do to Dick Masterson. So I want to be very clear when we're talking about who did what. Let's see. On January 25th, 2018, Herrera defames plaintiff Orangutan, incites his fans who appear to be anticipating and plotting Uzunian suicide. No. How do you plot someone else's suicide? How do you plot someone else's suicide? Even suggesting that Herrera will turn into more, will turn it into more content for his show. I'm sure if Maddox killed himself, that Dick, as a former friend and actually not a dirtbag, would probably, announce it on his show. Hey, we just got news that Maddox killed himself. It's really sad because he used to be a funny guy. I really don't think anybody would revel in the death of Maddox by suicide. Unless Maddox did it in a particularly satirical and funny way, like his guide on how to commit seppuku. Was that him? No, that was Real Ultimate Power. Maddox has a different way to commit suicide than seppuku. To be fair, Land DUI probably attributing the current profession to his father's efforts. Ooh, that's a sick burn. Herrera's fans have multiple suicide pools. Really? Where they encourage and coordinate harassment for Orangutan to kill himself. Mr. Orangutan receives these and similar messages from Herrera's fans. Does he really? Because he blocks all of Herrera's fans automatically. Yes, I think Maddox will drown himself in a tub of baked beans. Wasn't that his number one manliest way? I think number 2 was strangling himself, right? Snake Jerusalem would rejoice. Well, that's sad for Maddox. On January 25th, 2018, Herrera attacked Mr. Orangutan's recent book. The book can't accept the attack. Did he actually stab it or something? After he incited his fans to leave negative reviews, and after Mr. Orangutan had tried to explain some of those reviews to his fans in the mailing list. He tried to lie about what the reviews were, and pass off negative reviews as fake reviews, like you're still trying to do. I think you can see Rotten Tomatoes for an example of how to do this. In the example below, Herrera encourages his fans to harass Orangutan. One of Herrera's fans suggests they should all spam Orangutan's effing podcast voicemail. And that if he changes the number, they'll spam the new one too. Herrera responds and tacitly encourages, saying it would be nice to get an explanation out of him. Okay. Sukat Suto Clone. I can't even pronounce your name anymore. Capitalism make all this possible. Heart, thanks. Yeah, I think so. I love capitalism too. So let's see what is actually said. I'm not saying my views and opinions are in any way your own. Look at that disclaimer right off the bat. I think every dickhead should spam his effing podcast voicemail until he drops the lawsuit or the podcast. If he changes the number, we spam that too. Us, Dick, not you. Just sit back and let us take care of the rest of his hairline. That's a bald accusation. Dick Masterson replies, it would be nice to get an explanation out of him, which is like the most neutral and detached way to respond to that comment. And that becomes tacit encouragement. Not a chance. Not a chance. Grammarly ad as I tuned in. Defamation and threats against Kevin A. Landau, Esquire, in the Landau Group PC law firm. Guys, I'm laughing. I can't stop. I can't believe this is actually happening. And yes, we will get to the exhibits, moderator. They are the best part, especially for the fans. So stick around. The exhibits are coming. Herrera recently created a Twitter page in January of 2018 under the handle The $20 Million Man at space stand space with space dick. It's not his Twitter handle. His Twitter handle is at stand with dick, all one word. Adam Smith says, looks like Land DUI spent a lot of time crafting this. I wonder if he will submit timely responses to Weber Shandwick and Patreon's motions to dismiss. Only time will tell. Hopefully not for their sake. And hopefully not for his own sake, because when they respond, I guess I'm betting Weber Shandwick's response is going to be vicious. The sole purpose of this page, again, the sole purpose of this page is to defame and injure counsel for plaintiffs. But he tweets about other stuff, plaintiffs apostrophe, and incite and encourage others to do the same and to find private documents and information. No, it's also to promote his podcast. I believe he used it to get on the Milo show. You cannot say it's the sole purpose. There are several other purposes. And Hat Buckles. Has anyone ever been successfully sued for not being able to control the actions of fans doing things that were never suggested by the defendant? Not to my knowledge. I don't know how that lawsuit would possibly succeed. So not to my knowledge, but that's one of the things I'm definitely going to be looking for in the very near future. Baron Nathan Dean says, yo, I was late to the stream. Did you already say stuff about Blum being a Jane Doe in all documents? But this one, lazy copy paste. Jane Doe, to clarify, Jane Doe was not actually, or Jessica Irene Blum was not Jane Doe in all of the documents. But this one, the prior document, his response to Dick Masterson and Foundation Digital, they dropped the whole ruse that she was a Jane Doe and said she would be proceeding as Jessica Blum from now on. So they did that, and they actually addressed it in that previous one. It was live stream number 4. If you want to go back, I do cover it on there. Okay. And to find private documents. So again, so many more than the sole purpose of this page is to defame and injure counsel for plaintiffs, and it's no longer a sole purpose. Immediately not. Incite and encourage others to do the same, and to find private documents and information, comma, on plaintiff's counsel, comma, Kevin A. Landau, Esquire, comma, and his law firm, comma, the Landau Group, PC. Too many commas. And I don't know how his Twitter account would help him find private information on Kevin A. Landau. On February 5th, 2018, Herrera tweeted, Nick Rekieta will be live streaming himself taking a big poop on Maddox and his dumb F DOGBITE attorney. And he did that, and I thank him for it. I love the extra publicity. Landau should also retweet my live streams. Dying Maddox and DOGBITE Landau's latest legal limp dickery. Apparently, Dying Maddox and DOGBITE Landau were crafting their garbage responses to their garbage lawsuit today, and I'm censoring these. Probably because I'm not drunk enough to not do it yet. On February 7th, 2018, Herrera tweeted that he would be releasing private information and documents to his fans related to Mr. Landau, stating as follows. Slavic Donut says, man, I want some donuts. Send Landau a cease and desist to stop evoking your name in frivolous filings. Maybe go for an injunctive order to forbid him from saying your name again. That would be hilarious. That would be great. The Goss Demons. Hey, Goss Demon, you got a shout out. I just was getting there. Good job, buddy. The Goss Demons have just showed up at my place with their pizza oven and a special recipe involving DOGBITE Kevin Landau. I wonder what they're cooking up. We'll find out. On February 8th, 2018, in response to a fan finding and tweeting private documents and information about Mr. Landau, Herrera responds, God bless you. And yes, if you know Herrera, he is a devout Mormon man and thoroughly believes in the blessings of our Lord and Savior. On February 5th, 2018, Herrera even tweeted about this court and your honor being assigned to his case with a link to a website to where people purportedly write reviews of judges. Purportedly. Landau, I wonder if you've ever written a review of a judge on there. That would be interesting, wouldn't it? I don't know if there are any enterprising individuals who want to pour through the reviews on the New York website to see if Kevin A. Landau has ever written a review. I'm sure he wouldn't use his real name if he did, though. So we'll probably never know. Guys, I'm going to pour my second drink. I'm not going to start it yet, but this is 45th Parallel Straight Bourbon Whiskey. I really like this stuff. They're in Wisconsin. I don't know exactly where. This is like their bourbon. I've had their wheat whiskey. I have a bottle of their rye, and I haven't opened it yet. Their wheat whiskey's good. This bourbon is phenomenal. So I can't advertise that enough. They should sponsor my stream too. New Richmond, Wisconsin. It's right on the bottle there. Get some of that. Moderator, I'm getting there. Just a second. All right. Thanks for keeping me on track. I appreciate you even when I am frustrated by your insistence that I do things the right way. On his Patreon page, for episode 88 of his podcast, Herrera states as follows: Dying Maddox and his hype man / attorney, DOGBITE Kevin Landau, possibly the dumbest lawyer on earth. Are you calling that a statement of fact, Mr. Landau? Because if you're alleging defamation, you're saying that's a factual assessment of you. On bonus episode 18 of Herrera's podcast on November 16th, 2017, Herrera and a guest or his co-host Sean. No, it's not a guest. It's his co-host and partner in the podcast. We're discussing this LoLsuit, and counsel for plaintiffs and counsel for plaintiffs, and Sean. Guys. Counsel for plaintiffs, period. Sean stated that, and not a comma. Okay. Sean stated that an effing retard probably wrote it from the mind of someone who is not mental, who is sick. He has a mental problem. He is mentally disabled. Spicy bants from Sean. Yeah. That's still an opinion of you. Oh my gosh. On episode 77 of Herrera's podcast on November 20th, 2017, Herrera defamed counsel for plaintiff, stating that plaintiff had gotten a dog bite lawyer who was worse than an ambulance chaser. That's not defamation. Oh my gosh. Is anybody... Never mind. Does anybody remember where that dog bite thing came from? I know it's on Google. Kevin A. Landau, dog bite attorney in Michigan, right? Like, it's from there. Does anybody remember where that is or have the address for it? Can you throw it in the chat if it's simple enough? That would be hilarious. Yeah, Dr. Richard Ape, yes. This is great. Landau is just tearing himself apart. Yeah, I don't think he knows what to do at this point. On February 15th, 2018, Defendant Herrera actually disclosed counsel for plaintiff's private information, including his former address, date of birth, and court records. Court records are not private information, nor is a date of birth or former address that is included in the court record. To his fans by sending out a tweet indicating that he would be recording a bonus episode about said records and information. How did he disclose this in the tweet saying he would be disclosing it in a recording? That doesn't make any sense. That doesn't make any sense. Oh my gosh. Okay. So, section 3 is the novel length caption that actually spans onto another page. Like, what are you doing? Just clean it up. Clean it up. DOGBITE comes from his Avo, I think. I don't want to view his because he will see my profile if I look at it. Maybe I should, because he already knows I'm looking at his stuff. This is not a prior restraint. Sure. The undeviating rule of this court was expressed by Mr. Justice Holmes over half a century ago in Patterson versus State of Colorado ex rel Attorney General. The theory of our system is that the conclusions to be reached in a case will be induced only by evidence and argument in open court and not by any outside influence, whether of private talk or public print. Hey, Landau, then maybe you should stop including the outside influence, private talk, or public print in all of your motions in an attempt to influence the outcome of the judge's decision. You're literally violating Patterson versus State of Colorado right now. You're violating it constantly because you are constantly bringing in extrajudicial comments as some sort of evidence against you. Unicorn-shaped building says, from Avo profile, it shows practice areas, animal and dog bites, car accident, child custody, child support contracts, and agreements. There you go, guys. You can check out Kevin Landau on Avo. Let's give him a reference. Check out Kevin Landau on Avo, and you can see the dog bite thing until he finds a way to remove it. Freedom of discussion should be given the widest range compatible with the essential requirement of the fair and orderly administration of justice. Pennekamp versus State of Florida. Again, you're the one bringing extrajudicial comments into your court documents in an attempt to prejudice the case against Dick. And let's take a moment, guys, and let's let's look at what this really is. Someone asked earlier, and forgive me for not remembering who it was, but someone asked earlier if there was a strategy involved in filing this injunction and filing this request for relief from the court. Yes, it's a twofold strategy. One, it's to silence Dick without the court's actions. What they want to do, like they're talking about intimidation, but threatening to charge Dick thousands of dollars to fight frivolous motions is the restraint. That's the restraint that they're going for, whether a judge orders it or not. They're hoping that Dick doesn't even fight this. That's what they're hoping for. That's what they're trying to get him to do. Silence his First Amendment rights to free speech, and it's garbage, and he's a garbage attorney, because any attorney who tries to trample on the First Amendment is a pile of trash. It's honestly, like, let's take a moment here. The First Amendment is the most sacrosanct, sacred amendment in the Constitution. I know a lot of guys who are Second Amendment guys, and I'm glad that you are, but without the First Amendment, you can't defend any of them. We can't defend anything. So a lawyer who comes out against the First Amendment should be disbarred, in my opinion. In my humble opinion, you are a pile of trash, Landau, for attacking the First Amendment in this way. Nut up and just deal with it. Say, yeah, I'm not a DOGBITE attorney. It's an old AVO thing. Haha, funny joke, but I'm actually suing you right now. Fire back. Fire back. Grow some testes and fire back. What does any of our stuff have to do with your ability to represent your client? Nothing except what you allow it, you coward. By you cowering in the corner and whimpering to a judge that a bunch of people are mean to you because you happen to lie in legal documents over and over again, which you narrowly avoided sanctions for in another case, so don't pretend you don't know what you're doing. You are doing this, and your actions are disgusting to people in my profession. You're the kind of guy who gives us bad names while we're trying to help people, and you make me sick. You make me flipping sick. So what you're trying to do here is stifle that discussion, which should give the widest range compatible with the essential requirement of fair and orderly administration of justice, because you're bringing statements in through a frivolous motion to suppress the First Amendment rights of someone else. Get good. But it must not be allowed to divert the trial from the very purpose of a court system. They're talking about influencing jurors, like the judge is listening to this or watching my videos for assistance. Judge Ramos, if you're watching my videos for assistance, buddy, more power to you. Thanks for being a fan. To adjudicate controversies, both criminal and civil, in the calmness and solemnity of the courtroom according to legal procedures, which you aren't following. The right of the people to have free press is a vital one. The right of the people to have a free press is a vital one, but so is the right to have a calm and free trial, or fair trial, free from outside pressures and influences. They're talking about influencing jurors. It's State versus Van Duyn. That's a criminal case. They're talking about influencing jurors, not bothering you. You can turn off all of this. So can Maddox. You can just shut it down. You guys are already blocking everybody. Kevin Flesher says, who turned up the heat? #fire. I guess Land DUI did. Every other right, including the right of a free press itself, may depend on the ability to get judicial hearing as dispassionate, impartial as the weakness inherent in men will permit. That's criminal law. You're citing criminal law. This isn't going to be subject to that. We're not tainting a jury pool by being some multi-million follower news outlet. I would love to be. Make that happen for me, please. In the instant case, neither plaintiffs nor their counsel are seeking a protective order or gag order restraining the press, except that if you don't remember from your own citations that comedy and satire falls under the press as a newsworthiness exception to Section 50 and 51. So Dick is a member of the press under every constitutional definition we can muster, or any news media coverage of this case. And so am I, by the way. Ketchup Pizza says, have another drink, Landau. I don't know if he should. Actually, that might be a violation of whatever probation he may still have. Further, plaintiffs apostrophe are not requesting that any pleadings or motions or other documents filed with this court be sealed. Good. Please don't ruin my income. Instead, plaintiffs apostrophe, comma, and their counsel, comma, are seeking a gag order. You didn't need commas. Plaintiffs and their counsel are seeking a gag order. That go to school. Are seeking a gag order restraining defendant Herrera, comma, from making and encouraging any extrajudicial statements about this case, comma. You can't suppress someone's right to talk about their own case. You can't. You don't have any court orders. You don't have anything yet. You're at summary judgment. The judge can't even consider anything other than the legal actions in the motions and the original facts cited in the complaint. Thanks, Breakdance Express, for the donation. I really appreciate it. Or about plaintiff's apostrophe, or about comma, or about counsel for plaintiff's apostrophe, or his comma, or his law firm, or discussing the case, or referring to plaintiffs or counsel for plaintiffs on his podcast or any other social media and from restraining defendant Herrera from posting and encouraging the publication of any information, documents, or statements about plaintiff's apostrophe or their counsel or on any social media whatsoever. You cannot restrict the free speech of someone else in this way. Go back to con law. And whatever communist school you went to, go to a better one. Ugh. Gunsbeer Freedom 87 says he probably spent more time studying the bottom of a 40-ounce King Cobra instead of his school books. Yeah, maybe. Sukatsuto clone. Man, I cannot pronounce that name. Let's send drinks to Landau. It reminds me of Naksukao, right? From the White Warrior from Kickboxer. Cheers to another DUI. Ooh. Guys, he might have a real problem with alcohol. Defendant Herrera is targeting counsel for plaintiffs, harassing him, constantly making defamatory statements about him on his show, constantly, and defamatory being operative lies in that statement, and website, and throughout social media, and encouraging others to do the same in an attempt to encourage and incite his fans to target counsel for plaintiffs, and engage in fix your commas. And engage in an online harassment campaign similar to the ones alleged in the complaint. So, not really online harassment campaigns. Carlos Pena says, remove commies. Sarah Marie says, drink. This one's for you, Sarah. I miss you guys. When were we getting together again? Snake Jerusalem, we won't know that for, until the judge issues an order. All right. Where am I? Defendant Herrera is targeting counsel for plaintiffs harassing. Okay. Yeah. Encouraging others to do the same in an attempt to encourage and incite his fans to target counsel for plaintiffs and engage in online harassment campaigns similar to the ones alleged. Whoa, Andres, have a bottle on me. Thanks, man. I will. Any recommendations? Super hugely appreciate that, man. Thank you so much. And engage in an online harassment campaign similar to the ones alleged in the complaint. Herrera is doing this to profit. Looks like there's an extra space in there. Hard to tell. But, oh no, it's probably just center justification. But also because he is clearly a vindictive person. Well, I think that might be a defamatory statement. And dead set on retaliating against counsel for plaintiffs for filing the instant lawsuit and representing plaintiffs apostrophe in this matter. No. It's probably retaliation. If I had to speculate, it's retaliation for you lying over and over to the court. Like, that would be my gut feeling as to why he would be interested. Snake Jerusalem, have a good night, buddy. Have gun and say ya. Okay. Therefore, Therefore, as if he's reached some conclusion based on his own circular reasoning, Herrera is waging this war against plaintiff's apostrophe counsel. That's a proper apostrophe. Good job. Good job. That's a good boy. Plaintiff's counsel to profit and interfere with counsel's relationship with plaintiff's apostrophe. I think the biggest person maybe interfering with your relationship with your with the plaintiffs is me, suggesting that they might want to look into ethics violations against you because I don't think they're being properly represented in this matter. I think you're fleecing them for money. That's just my opinion. It's not a statement of fact. I don't know how much they've paid you, but if it's more than anything, I think, I'd question it. And or to try to get counsel to withdraw from the case. Please don't. Please don't ever. Please don't ever withdraw from this case. And or because he simply takes pleasure in humiliating other people. Or engaging in actions for which he feels there are no consequences. Because there aren't consequences to this action, not legal ones. Because Dick did nothing wrong. I'm going to say it again. Dick did nothing wrong. There is no room in litigation for this type of behavior. No, there's tons of room in the public sector for this type of behavior. And it's not in litigation until you bring it into the court. And Herrera's targeting of plaintiff's counsel is reprehensible and is afforded no protection under the First Amendment. From this line of reasoning, it is clear that while commercial speech is protected under the First Amendment from prior restraint, the protection afforded is less than that provided for non-commercial speech. It's not commercial speech. Commercial speech. So that when commercial expression is false or misleading, it is afforded no protection whatsoever. They're referring to false advertisement and fake signage. Fake commercial speech, not opinion that generates revenue. Go back to law school. You should have failed. Demand a refund and go get a job at Walmart. Oh my goodness. Numerous examples could be cited of communications that are regulated without offending the First Amendment, such as employers' threats of retaliation for the labor activities of employees, because that's barred by a statute that's suppressing the employee's political speech. That's a statute protecting speech, you dummy. Further, a protective order, in this case restraining defendant Herrera's speech, is not a prior restraint of the media or press coverage. It absolutely is. Instead, it is simply a protective order restraining a trial participant from making any extrajudicial statements about the case. But you don't do that. Or from speaking about plaintiffs or their co-counsel whatsoever. See in RE application of Dow Jones Company. You don't do that. Is not drinking. Guns Beer Freedom says it's not drinking alone if it's in this live stream, is it? I'm betting Landau hopes not, as he watches this and cries. Breakdance Express says, does Landau have a diaper and a Kleenex donation link? Not that I'm aware of. Slavic Donut asks if I can expand what a prior restraint is. Yes. Sorry, guys, if you need these terms of art explained, please don't hesitate to hit me up on it. A prior restraint would be simply a restraint preventing speech, not without assessing whether the speech is proper or not, right? In this case, it is a prior restraint. Like it absolutely is, because they're saying that they don't want Dick to make any statements whatsoever about the plaintiffs or about the plaintiff's counsel, no matter what they contain. Now, if you're restraining or enjoining defamatory statements, which are presumptively enjoined because they're illegal in the first place, but if you're enjoining defamatory statements, that's not a prior restraint because that is a permissible ban. Defamatory statements are not protected statements by the First Amendment. You can't lie to hurt other people as protected speech. However, a prior restraint would be an impermissible restraint on protected First Amendment speech. I hope that clears it up. Andrew Hicks says, I worked at a Walmart. No one needs a hellish job any more hell than it needs to be. Hicks, thank you so much for that comment. Gag order restraining trial participants from speaking with the press in criminal case arising from alleged corruption by public officials in obtaining federal contracts was not a prior restraint on press in violation of the First Amendment. Order was directed at trial participants rather than the press. Here you go again, talking about something that is so far out of scope as to be offensive. I got to move on, because I could sit in this section all day and I'll just get angry to the point of calling a hospital. The court again enunciated the principle that the state may intervene to protect the public from harmful commercial speech in O'Reilly by stating that, quote, the state has a legitimate and indeed compelling interest in preventing those aspects of solicitation that involve fraud, undue influence, intimidation, overreaching, and other forms of vexatious conduct in the course of business. Yes, they have a compelling interest to prevent illegal activity in business. You dumb idiot. Throughout its history, the Supreme Court has heard numerous cases involving a conflict between free speech and fair trial. In each of such cases, the court employed a balancing approach to assure that neither of those fundamental rights encroach too far upon the other. The right of free speech, strong though it may be, is not absolute. It should be. When the right to speak conflicts with the right to an impartial judicial proceeding, an accommodation must be made to preserve the essence of both. There's no evidence that Ramos is going to be influenced by Dick's Twitter feed. You dork. In Quinn, after undertaking an exhaustive discussion, the court discussed a similar issue as that of the instant case. In Quinn, certain insurance advertisements were at issue, which the court noted do not direct their attention solely to the general public for informational purpose only, and what was really at issue was more than pretrial publicity or trial reporting. You sure cut a lot out of that. And I have not gone through Quinn versus Aetna in a while. And so I'm not going to say you're wrong, but I'm going to assume you're wrong because you're so flipping bad at this. Accordingly, the court found that despite the defendants' claims that they were merely advocating tort law reform, there was an inescapable implication that the advertisements were geared towards influencing jurors and potential jurors in their decision-making process. Commercial speech is not a podcast. A podcast is not commercial speech. As such, the Quinn Court found that the advertisements at issue violated the state's public policy expressed in Section 215.25 of the Penal Law relative to jury tampering. For that reason alone, the speech might properly be restrained, as it has been held that the press is not immune from statutes of general applicability. There is no evidence that Dick would have any ability to tamper with a jury. He's not CNN. He can't influence. I mean, I love you, Dick. You got a ton of fans all over the earth, but the idea that 12 random idiots in New York are going to be all fans of Dick Masterson and subject to his Twitter account and banter, and that will be influencing to them, is nonsense. More to the point is the reasoning stated in New York State Broadcasters Association versus United States. The real point here is that we are not primarily in the realm of ideas at all, but are chiefly concerned with speech closely allied with putting into effect of prohibited conduct. It's not prohibited conduct. You're talking about false advertising. You're talking about illegal activity. Justin Brodak says, what would Dick have to do for him to have a case? I don't even know. That's how crazy this is. Okay, defamatory statements are presumptively illegal. So he would have to actually lie. That would maybe do it. Psych. Noah G says psych. I don't know what HK 555 actually translates to, but I appreciate that. Thank you so much. I don't know. The live chat seems to think it's a ton, but I have no idea if it is. Thanks a bunch anyway for your donation. How quickly does the restraining order process move, or is this part of the actual lawsuit? Typically, something like this should be pretty fast. I don't know if we'll see the result of this or not. I imagine either there will be an order on this or some stipulated thing, but I'm not 100% sure. Here, the court clearly has the authority to make such an order restraining Herrera from making any extrajudicial statements about plaintiffs, but especially about their counsel and his law firm. I don't actually think the court does, based on what we've seen. The court also has a duty to take such precautionary safeguards to prohibit such conduct from further infecting this litigation. It's only infecting this litigation because you're bringing it into the courtroom. No one else is. No one else can possibly put these words in front of a judge but you. But also to protect the sanctity of this court and members of the bar who have the honor of practicing in this court. Oh, you dirtbag pile of garbage. How dare you? Without fear that by doing so they may face threats. You haven't faced a single threat. Retaliation. You haven't faced retaliation. And an online harassment campaign. You haven't faced an online harassment campaign. You just haven't. Waged by an opposing party and his fans. Not by an opposing party. Simply for representing an adversary. Herrera's vindictiveness and conduct against another party to a litigation. No, his continuance in his protected free speech activities, which include making fun of Mr. Orangutan and their attorneys. Yes, and his attorneys. Has no room in this court. It's not in the court except for you and is reprehensible under our civil legal system, as well as our criminal law. Nope. No, it isn't, you liar. And cannot be tolerated by this court and should be sanctioned and restrained accordingly. Really? Do you really want to discuss sanctions, Mr. Landau? Further, defendant Herrera's threats that he will release private information. It's not private. Private information. Oh, lovely. Private information on his, let's see, where is it? Sorry. On plaintiff's counsel as gossip or content for his show and encouraging and inciting his fans to do the same is not only vindictive and retaliatory, but it is tantamount to extortion or coercion in the second degree under penal law. Expose a secret or publicize an asserted fact, whether true or false, tending to subject some person to hatred, contempt, or ridicule. They're public documents, buddy. They're public documents. And I'm pretty sure you're reading that way out of context. Further, Herrera's constant harassment and threats towards plaintiffs and their counsel likely violate Penal Law 120.45 and Penal Law 240.30 respectively, except they don't because they're protected speech. Aggravated harassment in the second degree may be committed by sending harassing or threatening messages by email. Where? What harassing or threatening message did he send to you by email? Harassing and threatening message posted on an internet news group was a type of communication prohibited by statute. Government. You have to fulfill the statutory requirements of harassment and threat. Clay, you missed all of the drinks. Guns Beer Freedom says, I can tell you right now, as the person who released those documents, I was not in any way encouraged by Dick. Uh-oh. I guess that's a problem. Accordingly, Herrera has no protections under the First Amendment for his repulsive conduct and must come to an end immediately. And must come to an end? Herrera must come to an end? Guys, he's calling for Dick's death in a legal case here. That's really unfortunate. Constitutional free speech protections have never been thought to give absolute protection to every individual to speak whenever or wherever he pleases, or to use any form of address in any circumstances that he chooses. A person's right to free expression may be curtailed upon a showing that substantial privacy interests are being invaded in an essentially intolerable manner. You don't have a privacy interest in public records. You just don't. In the instant case, based upon the abundant evidence submitted in support of this motion, and the authority briefed above, it appears reasonably certain that defendant Herrera's harassment, threats, conduct, and statements present a reasonable likelihood of a serious and imminent threat to the administration of justice, thus necessitating court intervention at this time. People versus Buttafuoco. I think he misspelled Buttafuoco, but I'm not sure. Plaintiffs meet the requirements for the issuance of a preliminary injunction under sections 349 and 350 of the general business law. The decision to grant a motion for preliminary injunction is committed to the discretion of the trial court. Preliminary relief is only appropriate where, 1, the moving party is likely to succeed ultimately on the merits of its claim. They're not. They're really not. And I think Kevin Landau knows that. I think Kevin Landau knows that they're not likely to succeed on the merits of the claim, and he is merely using this as a tool to intimidate Dick and to force him into silence. And it's disgusting. There exists the prospect of irreparable injury in the provisional relief if the provisional relief is withheld. No, your DUIs caused the irreparable injury, Landau. Your drunk driving put the entire public at risk and then put on public record that you are a menace to society when there's a car and alcohol anywhere near you. That's what causes the prospect of irreparable injury, not the fact that someone points it out. The balance of equities tips in the moving party's favor. No. Let's see. Because plaintiffs are, do I think Maddox was inspired by Weird Al's song, I'll Sue Ya? No, probably not. I don't think so. Because plaintiffs are seeking a preliminary injunction pursuant to sections 349 and 350 of the GBL, the irreparable harm analysis in this case differs from a traditional preliminary injunction analysis. Sections 349 and 350 on their face entitle private plaintiffs to seek injunctive relief so long as they have suffered an injury as a result of a defendant's deceptive acts or false advertising. You haven't, though. You haven't. And you're not asserting, injury to the plaintiffs. You're asserting injury to you and your fragile ego. But they have not suffered an injury as a result of any deceptive acts or false advertising. You made that up with a poor legal argument. That's what happened. Accordingly, courts have treated future irreparable harm to the public as sufficient to obtain a preliminary injunction under 349 or 350 of the GBL. Regardless of whether plaintiffs are in fact required to prove irreparable harm in this case, they are. Oxygen Induced says, the watermark is good, but could you try and not read anything towards the bottom of the screen that it covers? Love the new layout. Yes, I will do that. Sorry, old habits. Plaintiffs can make such a showing. No, they absolutely can't. As demonstrated herein, consumers will suffer irreparable injuries unless defendants' deceptive acts and false advertising are enjoined. There are no deceptive acts or false advertising. You're trying to say a joke that Madcucks, who is obviously not Maddox, and no one is confused by this, a joke that he is Maddox is a deceptive practice. A joke made on a fan forum to fans who are familiar with the subject matter. No one went to Madcucks because they thought he was Maddox. They all listened to Madcucks because he hilariously mocks Maddox. Put it right above the chat box. Let's see. I can move it, but I'd have to shrink it. Let's shrink it. Here we go. How about that? That'll work for now. Anyway, to prove that a practice was deceptive within the meaning of the statute, harmed consumers must show. You don't even have a claim under your own definition because Maddox isn't a consumer of his own product. The act or practice was consumer-oriented. The act or practice was misleading in a material way, and they suffered an injury as a result of the deceptive act. I think actually now that this is brought up that I remember that. You don't even get to claim 349 and 350 because you're not the consumer and you're not on behalf of the consumer. You're acting on behalf of the aggrieved party who would be Maddox, not the consumer, but the producer, the content creator. Defendants' deceptive acts and false advertising were consumer-oriented in New York. Oh, this'll be rich. Let's see what these footnotes say. Any person who has been injured by reason of any violation of this section may bring an action in his own name to enjoin such unlawful act or practice. Any person who has been injured by reason of any violation or section 350 or 3... here, guys, just so you know, let's point this out. So ever since I started making fun of Landau, I've been getting nonstop calls from people associated with Maddox. What people aren't doing to Landau, right? No one is calling and harassing Landau. People actually do to me. People actually do that to me. But we don't do that to Landau. So maybe Maddox and his sad little band of cronies should consider that they are actually engaging in the acts that Maddox routinely argues are so degrading and demeaning and stressful for them, because they're the ones who actually do it. Let's see. Okay, so any person who has been injured by reason of any violation of this section may bring an action in his own name to enjoin such unlawful act or practice. Any person who has been injured by reason of any violation of section 350 or 350A of this article may bring an action in his or her own name to enjoin such unlawful practice. Hatbuckles asks, is this lawsuit Maddox's suicidal attempt to get credit for the snacks a la Sue Snack Bar? A la Sue Snack Bar. That's hilarious. Guns Beer Freedom, I missed yours. Sorry. Maddox is probably the only consumer of his product. I think at this point that is true. Certain courts in New York have further suggested that Section 349 of the GPL is such a broad remedial statute, similar in nature to federal regulatory statutes, that a showing of irreparable harm is not even necessary to obtain an injunction. Certain courts have further suggested. No courts have actually ruled that way to my knowledge, but I'm not an expert in New York law. So, to be consumer-oriented and therefore actionable, deceptive acts that are private in nature must nevertheless have ramifications for the public at large. The gravamen of a Section 349 claim is a consumer injury or harm to the public interest. You haven't shown that. You haven't shown any consumer injury. You could have even lied and created one. You lied in several other places. I'm surprised you didn't. Allegations that the acts complained of potentially affected similar situated customers are sufficient to show the deceptive acts have ramifications for the public at large and warrant injunctive relief. You still have to have a customer raise this action. A customer has to raise this action. That's who brings it. A deceptive practice or false advertisement will likely be consumer-oriented if it is a standard practice of a given individual or company. Okay. Here, as thoroughly examined herein, and again, so strong with the claim of what has thoroughly happened. Herrera's conduct since being served with this lawsuit harms the public interest and the parties in litigation in this courtroom. Further, in addition to the recent acts of Herrera outlined above, he also bought multiple targeted false advertising campaigns on Reddit and Facebook targeting Plaintiff Azunian and his fans directly and suggesting that Plaintiff Azunian's fans should unsubscribe from his podcast. Guys, false advertising is promising a product and delivering something else. It's my office line, guys. That's what's ringing. Yes, my phone is vibrating because I'm getting harassing calls, and they're doing voicemails too, which is great. I'm getting harassing calls from people from the Madcast Media Network. So again, a false advertisement would be one that promises something and then fails to deliver in the actual product that is purchased. Dick has not done that in any way. And no, I'm not going to answer the phone live on air. Okay. Let's see. Here, as thoroughly examined, Herrera's conduct since being served with this lawsuit harms the public interest. Alan Foster, paid ads, stop giving Nick money. And the parties in litigation in this courtroom. Wait, no, I don't like that. Don't do that. Further, in addition to the recent acts of Herrera outlined above, he also bought multiple. If the messages have merit, I might, but from what I can tell, they're not interesting. He also bought multiple targeted false advertising campaigns on Reddit and Facebook, targeting plaintiff Orangutan and his fans directly and suggesting that plaintiff Orangutan's fans should unsubscribe from his podcast. Nothing illegal about that. This does not satisfy the consumer-oriented element under GBL 349 and 350 because there is no consumer raising this claim. That's the crucial point. We'll see. Okay, I'm not going to read that citation because I'm getting bored with the citations. Further, and we got to get through this document so we can get into the juicy follow-up document. Further, defendants use similar harassment campaigns, you got a bad apostrophe again, and trolling against consumers and plaintiff orangutan sponsors. The deceptive acts and practices and false advertising, gosh, they're just constant legal conclusions that Herrera has engaged since being served with this lawsuit are clearly identified throughout this pleading and attached exhibits. No. It's funny that your inability stretches this far, as well as contained within the affirmation of Kevin Landau, Esquire. Therefore, defendant Herrera's action towards plaintiffs were and continue to be materially deceptive and misleading business practices and directed at thousands of consumers, including plaintiff Azunian's fans, which caused plaintiffs' apostrophe substantial and ongoing harm and injuries. Sukatsu. I'm going to call you Naksukao. Sukatsu do clone. Oh my gosh! Happy Chinese New Year of the doggo. Oh goodness. Therefore, defendant Herrera's actions towards plaintiffs were and continue to be materially deceptive and misleading business practices and directed at thousands of consumers, including plaintiff Orangutan's fans, which caused plaintiffs substantial and ongoing harm and injuries. Falsely advertising customer services and disseminating fictitious testimonials over the internet, such as disguised source of email messages to group members. I don't know why he has that bolded, was sufficient as basis for false advertising charge. Defendant Herrera's various deceptive acts and practices were and are standard practice for his business, as demonstrated by the foregoing, even after being sued. That's because the reason he continued after being sued is because what you sued him for isn't illegal. He continues these practices unabated. All of these deceptive acts and practices and false advertising, you can keep saying it, but it doesn't make it true. Were designed to drum up business for his podcast. Then how are they deceptive? If he's telling people, come watch my show, for the purpose of getting people to watch his show, how are they deceptive? Increase his fan base to sell his book. These are all legitimate advertising purposes. There would have to be a law. Sukao. There you go. That makes sense. Let's see. Increase his fan base, sell his book and other merchandise, as well as his road tour. It is a critical part of defendant Herrera's business plan that these illegal practices be easily repeated to deceive numerous similarly situated customers. It's not a deception when you tell them to unsubscribe. Like, unsubscribe from his show and watch mine isn't deceptive. That's overt. Since without the ability to disseminate their deceptive advertisements, hate, and false information on plaintiffs, it would be impossible to defendants to find vulnerable customers online to fleece. Oh, Landau, you would know all about fleecing vulnerable customers, wouldn't you, you scum? Given this confluence of factors, it is beyond cavil that defendant Herrera's deceptive practices and false advertising were consumer-oriented. Dax Herrera's deceptive practices were and continue to be materially misleading. A practice is misleading if it is, quote, likely to mislead a reasonable consumer acting reasonably under the circumstances. Defendant's collections of hundreds of thousands of dollars in upfront fees for his podcast, tours, merchandise, books, and other content created by defendants' rapacious commercial exploitations of plaintiff's name, image, photograph, and likeness violates civil rights law 50 to 51. Nope. It sure doesn't. And no one, by the way, no one is buying this show because Maddox's name is listed on it. Not a single person is buying the show because Dick says the name Maddox. Not one. And should be treated no differently than the imposition of other illegal fees for false advertising and misappropriation. Here is demonstrated above, and in plaintiff's complaint, the instant misappropriation by defendant Herrera is appalling and has continued during this litigation against plaintiffs, whereby he continues to harass, threaten, intimidate, and exploit plaintiffs and their counsel, to create content for his podcast and other social media, and to retaliate against plaintiffs and their counsel for filing the instant lawsuit against him. The fat hipster says, Alkevin Landau. Plaintiffs each suffered an injury as a result of Dax Herrera's deceptive acts and false advertising. Deceptive acts and false advertising under general business law are for consumers, not for creators. For a deceptive act or false advertising claimed to be actionable, the injury suffered must be a loss independent of the initial deceptive act. Monetary loss is sufficient to state an injury under Section 349. Guns Beer Freedom says, I am buying the show precisely because it does not say Maddox. And I think you're right for most of us. Most of us are in the same boat, buddy. As further elaborated above and in plaintiff's complaint, plaintiff's losses include, but are not limited to, a substantial increase in attorney's fees and costs in this litigation. No, no, no. You don't get to do that. You don't get to sue someone and then complain that you have substantial costs. You don't get to file frivolous motions and complain that you have substantial costs. You don't get to improperly join parties and complain that you have substantial costs. You don't get to do that. The court knows that you don't get to do that. Your own legal fees can't be a financial hardship. Get bent. Which is significantly increased as a result of his instant threats. Nope. And harassment campaign since being served with the lawsuit. They increased because you're a charlatan. You're a charlatan. You do this in every lawsuit. Every lawsuit of yours I've looked at, you get dismissed for improper joinder of parties. You push misleading and false statements upon the court. All of the lawsuits have similar problems to this. You're the one who doesn't know procedure. You're the one charging your clients too much money, and you're the one raping them out of their money. Oh my gosh, you're disgusting. Loss of sponsorship and business, significant emotional distress and mental anguish, and other costs and substantial time incurred defending and protecting themselves from Herrera's constant harassment, threats, defamation, trolling, and stalking. None of Herrera's fans are not following Maddox because of Herrera. They're not following Maddox because of Maddox. That's why. Protecting themselves from Herrera's constant harassment, threats, defamation, trolling, and stalking, which has now interfered with plaintiff's relationship with counsel and forced them to incur tens of thousands of dollars in additional attorney's fees and costs. Maddox, please file an ethics complaint against this guy. Please do it. I can't give you legal advice. Talk to an attorney in California. Talk to an attorney in New York. Do something about it. If he's charging you tens of thousands of dollars for this garbage, you're being fleeced. You're the sucker. We all know that you're bad at this, so I'm going to help you out. Talk to an attorney in New York about Kevin Landau. Elijah Watson says, are we bad people for insulting the special needs kid and his lawyer? Man, I don't know. Maybe we are bad for insulting Maddox. A preliminary injunction is available when plaintiffs can show that a defendant threatens or is about to do or is procuring or suffering to be done an act in violation of the plaintiff's rights respecting the subject of the action, but he's not. Irreparable harm will redound to both plaintiffs and the public at large, absent an order from this court enjoining defendant Herrera's deceptive and unlawful activities. Not true. Allowing defendants to continue their course of it's not unlawful conduct will irreparably injure citizens both inside and outside the state of New York. Next section. Plaintiffs may satisfy the irreparable injury requirement by demonstrating irreparable harm in the future. As we have seen, Landau is an expert at discerning acts in the future. In cases brought under sections 349H and 350, plaintiffs may satisfy the irreparable injury requirement by demonstrating future injuries will accrue to the public. Because plaintiffs are functioning as private attorneys general, they are broadly, what are you even saying? Empowered to protect the general public? Guys, Maddox is claiming to be acting on behalf of the public in this case. That's what that statement means. They're broadly empowered to protect the general public against deceptive acts and practices and false advertising. Marcus versus Jewish National Fund stands for the proposition that future harm to the public at large is a sufficient basis for granting a preliminary injunction to private plaintiffs under Section 349-350. In Marcus, supporters of certain groups whose aims included the development of Jewish life in both Israel and the territories, shout out to Maxwell Kimball, acquired during the Six-Day War, asserted claims inter alia under 349-350 of the GBL against nonprofit fundraising organizations. Jaime says, in before Rekieta Law gets cease and desist from Landau or Maddox. Thanks for all the streams this week. Cheers. Thank you guys for watching the streams. You make this so much fun to do, in all honesty. Plaintiffs alleged that the defendant fundraising organizations deceptively suggested it in its advertising materials that it would distribute its donations to areas over the Green Line in Israel when it, in fact, did not distribute donations in this area. On appeal, so that's a false advertisement. We will do this and then we don't. Unicorn-shaped building, I don't know. I think maybe Maddox is pushing on spending more money on the DOGBITE lawyer than his website at this point. It's got to be close. He's got to be spending just a fortune for all of these motions. On appeal, the First Department determined that the plaintiffs had stated a valid cause of action under 349 and 350. The court then ruled that plaintiffs had met all the requisite elements of the issuance of preliminary injunction, and in particular focused on the irreparable harm element. Clearly, if defendant were allowed to persist in its deceptive practices, of taking money from people and promising to spend it in a particular charitable way and then not doing it, that is not what Dick has ever done, to my knowledge. Certainly not in the context of this show. There would be a significant risk that people would read defendants' literature and contribute monies under the mistaken impression that their donations would be allocated to territories across the Green Line and thereby be irreparably injured. Right, because they lied about why they were taking money. Dick has never lied about why he's taking our money. What's up, Rage TH22? I'm glad you're able to catch this at work. It's not the size of the cuck, it's the motions filed for emotions. I agree. The Marcus Court expressly considered the future harm that would accrue to the public were the defendant permitted to continue distributing its deceptive literature. You are so bad at this. Like, you don't even address the distinguishable characteristics of this and attempt to dismiss them. Guys, if you're doing an argument like this, where you're citing something, what you should do is read your citation, find the weaknesses in the argument, and address them right after the citation. Say, you know what? The other people are going to say this, but that's not right because of this. That's how you do this. And if you don't do it, then you look like you don't know what you're doing. If you anticipate their arguments and address them, you undercut their ability to respond. The irreparable injury was therefore not tied directly to the plaintiff's asserting claims. Rather, the court considered irreparable harm to the public as sufficient harm to warrant granting the preliminary injunction. Yes, because the public was being defrauded out of money. I'm losing steam because I'm getting beaten down by the stupidity. Have you made enough donations tonight to start your own lame voting website? I don't know if I've made $30,000 yet, Neil Purcell. All right. Were defendants permitted to continue their deceptive practices and false advertising in violations of sections 349 through 50, public would suffer significant irreparable injuries, like the donors and Marcus who made donations under the mistaken impression they were being used towards a specific purpose. Here, plaintiffs have suffered a panoply of injuries, and their entire lives have been turned upside down as a result. You're talking about protecting the public, not plaintiffs. You can't cite the plaintiff's injury when you're talking about protecting the public, for which no adequate remedy at law exists. If no adequate remedy at law exists, then you defeat your case. Part of every element of every civil tort is the ability for the court to provide redress. If the court can't provide redress, then you don't have a claim. Dismissed. These are precisely the kinds of irreparable injuries that 349-350 were created to guard against, which warrant preliminary relief from the court. Finally, Marcus comports are the plain readings of 349-350, which authorize the deceptive conduct at issue. Dax Herrera's entire business model of accepting upfront fees for his podcast based on misappropriating plaintiffs' apostrophe and of their counsel's name, image, and likeness, releasing their private. That's not what it's based upon. That just happens to be a bonus of the content, and everyone gets that when they pay their money. Adam Smith, man, why do I not get notifications of these live videos when they start? I don't know, buddy. Maybe because I'm shadow banned. And constantly defaming, threatening, and harassing them through internet mobs who he directs to target plaintiffs' fans through internet mobs, right? Yeah. Who does that, Maddox? Sponsors, family, and business associates in an attempt to destroy their lives and businesses, interfere with their relationship with their attorneys, retaliate against them, and or cause them to suffer a nervous breakdown or destroy their lives in the process, may be enjoined by any person who has been the victim of these deceptive acts or practices or false advertising. Further, as demonstrated above, Herrera will not stop and has increased his threats and harassment against plaintiffs and their counsel since being served with this lawsuit. Therefore, plaintiffs have clearly shown that a future harm will accrue. Nope. Not under the statute. No future harm under the statute because they're not the consumers. I mean, maybe they are, but they're trying to sell themselves as not. The balance of equities tips in favor of the plaintiffs. I mean, this is going to be tiring, guys. Alan Foster, here's another couple bucks to remind you to refill your glass and take a drink. I will do one more. I'll do one more drink. Let's see what we got. Let's go with White and Mackay. Sorry. Balancing the equities simply requires the court to look at the relative prejudice to each party accruing from a grant or denial of the requested relief. Here, the prejudice that plaintiffs and the public at large, that's what you made up, will suffer absent a preliminary injunction is all too clear. All too clear, except now you're going to spend several paragraphs explaining to us how it's so clear. Defendant Herrera's entire operation is illegal. Really? It's not even in violation of Patreon's terms of service, you dolt, or YouTube's, or Google's, or iTunes. It's not in violation of any terms of service, but it's illegal and in violation of numerous civil and criminal statutes, including all of the ones listed every single time. There's simply no reason to allow him to continue exploiting plaintiffs and now their counsel. There's lots of reasons, the First Amendment being the biggest. Nor is there any reason to permit his flagrant violations to persist. Excuse me. Allowing his business to continue in any capacity. Oh, hey, before I get back to liquor, let me get a sip of this. Allowing his business to continue in any capacity creates an imminent risk of harm to plaintiffs and consumers in general. As has been demonstrated above, Defendant Herrera's entire organization is a sham. So apparently it's not an organization designed to get money for making fun of Maddox. Like, these arguments are so inconsistent. Accordingly, the prejudice that he will suffer as a result of an injunction is minimal. That's actually not true at all. This entire thing is designed specifically to prejudice him in front of the eyes of the judge. That's what it's designed to do. And you know it. Because his entire operation is per se illegal. Under the law, automatically illegal. Because I said so, it just is. No one has found that but Landau. The only harm that will directly accrue to Defendant Herrera as a result of injunctions is that he will be restrained from doing what is already forbidden. But according to you, that's the entire basis for his business. Running an illegal company whose entire business model relies on defaming, harassing, misappropriating, threatening, and using plaintiffs and now their counsel's name, image, likeness, photographs. So the funny thing will be, is if the judge enjoins Dick, Captain Weeb 56 says, keep up the good work. Thanks, buddy. I will not stop. If the judge were to enjoin Dick, or if Dick were to agree to no longer make fun of Kevin, the person who can't pass a field sobriety test, Landau, if he were to agree to that, and his business persists, then I suppose it undermines every single claim in your stupid, stupid lawsuit. Why would you set yourself up for your own claim to fail? Because if his business persists without making fun of you or Maddox, then he wins. Then every claim you raise is a lie. Plaintiffs know all too well the personal and financial pain wrought by defendant Herrera. Are you suffering financial pain, Maddox? Why do you keep maintaining that you're a success if you're suffering financial pain? And his co-conspirators. By the way, I think that amounts to accusing people around Dick of a serious felony, right? Conspiracy. And they now seek an injunction in hopes of preventing any future injuries to themselves or others so they can fairly litigate this case and continue their business and life without fear of reprisals or retaliation from defendant Herrera. You know, one problem with the legal system, guys, is that people like Landau are allowed to actually commit defamation constantly under the guise of zealously advocating for their client. But what Landau is doing, were it not in a courtroom, would be per se illegal. Landau would be violating the law right now if he published this document in like a journal of some sort, as opposed to in a courtroom. So, Andrew asks, is land DUI a better lawyer than 18? That's a joke from my law school. No. Landau is an effing coward. The worst part is that he can't possibly be the only lawyer to do this, or even the worst. He might be the worst. He might be. In all honesty, this is really bad. As such, the balance of equities requires preliminary relief. Like, you don't actually talk anything about the balance of equities. You just spout off the same boring nonsense you've spouted off this entire case. You made it all up. None of it's supported by fact. None of it's supported by law. Plaintiffs are likely to succeed on the merits. Oh, that is not true. If there's anything that the plaintiffs are least likely to succeed upon, it's the merits. It's the merits. The Tomekeeper asks, colloquial use of per se is to mean technically. What's the actual legal definition? The legal definition of per se would be as a matter of law. Okay, so if I say something is per se defamation, then as a matter of law, that is defamation. It doesn't matter, so sometimes you have intent, right? You have intent in defamation. You're intending to say a false statement about someone. But if something is per se defamation, you get to skip that intent requirement because this type of thing is specifically illegal in all circumstances, no matter what the intent is. Mad Cucks, Rick Moranis in Ghostbusters 2, hands down. Alan Foster, yes, you did. Sorry. Here, buddy. Good night, Windows 95. Thanks for joining us, man. Always a pleasure to have you in the stream. Go eat some soy. In discussing the probability of success in the context of their application for preliminary injunction enjoining defendants' fraudulent conduct, you're not enjoining their fraudulent conduct. You're enjoining their defamatory conduct, right? The plaintiffs have also established their likelihood of success on the merits. Nope. They're not likely to succeed on any other claims asserted in the complaint. Certainly not all other. Plaintiffs may also seek injunctive relief for Herrera's violations of 50 to 51. Oh my God, why? There's only a couple pages left. Section 50 provides a person, firm, or corporation that uses for advertising purposes or the purposes of trade. Guys, I have gone through time and time again why this is not true. Why this is not true. Saul Goodman is better. Mad Cucks. Having defined the offense and declaring it to be criminal, 51 goes on to provide civil remedies for the violation as well, including injunction and damage. Once a violation is established, you haven't established the violation. The plaintiff may have an absolute right to an injunction regardless of the relative damage to the parties. You haven't established the violation. You don't get to move on what you might establish. Cucks, yeah, I think Monsanto should sue Landau for defamation. In Onassis, the court posed a simple question: is there a violation? No, in this case, there's not. In order to establish a violation, plaintiff must demonstrate that the defendant used the plaintiff's name, portrait, picture, blah, 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 without permission. And again, they're going to misuse and abuse these citations and ignore the fact that you have to use it for publicity, not because you're talking about someone you're going to comment on. You're right, moderator. I'm going to skim through these ends. May seek redress, rapacious commercial exploitation. Guys, this is in every single one of his documents. You can tell he's really proud of this claim, and it's really bad. So for him to be proud of something and keep pushing it over and over is just sad. As Trump would say, sad. Such commercial exploitation, vindictiveness by one party to a litigation against another party and their attorneys, looks like Landau is hurt, is reprehensible under our civil legal system and cannot be tolerated by this court. As demonstrated above, there's no dispute that defendant Herrera commercially exploited the plaintiffs in their counsel's name. Yes, there's all sorts of dispute on that. Any argument that orangutan may be a limited public figure is of no consequence, except it really, really matters for the defamation claim, and that's where they raised it. They didn't raise it in 50 to 51. Stop acting like they did. Further, the content at issue created and exploited by Herrera is meant solely to harass, injure, and intimidate plaintiffs and their counsel. Nope. It's also made for the Skrilla and the fans. Oh gosh, this is so boring. Guys, we're going to go to the conclusion. I'm just tired of reading the same things over and over, and they're always wrong. They're always wrong. For the reasons set forth above and based on the affidavits, affirmations, and exhibits submitted herewith in support of this application for a temporary restraining order pending the hearing of plaintiff's motion for a preliminary injunction, plaintiffs respectfully request that the court grant its application in all respects and award them attorney fees and costs incurred since the inception of this litigation. No, they should not do that. It's nonsense. John Rekieta of Night Court is better. All right. Yes, it's afraid. It's afraid. Okay. So here's the affirmation of Kevin Landau. I haven't gotten to read this. Let me skim through it. I heard it's just a rehash, and I think that's probably true. All of this stuff is in the exhibit. So I think we should just go to the exhibits. This stuff is pointless. Yeah, all of this stuff is from gross. All of this stuff is from the document, which he could have written a shorter document and just cited this, but he chose not to because, let's be real, he's trying to cost Dick money. Whoa, that's wrong. Okay. Let's see. Where are we? Landau exhibits. Okay. So the Landau exhibits document, Landau exhibits document is 118 pages because for some reason he included the complaint in his exhibit. Let's just move through these because these are funny. These are funny. These are all the things he talked about in there. This, guys, this is for you. If we read through this and you see your name, like throw it out in the chat. Enjoy the heck out of the fact that you're called out in this lawsuit. You're immortalized because this will never disappear. Why does Landau keep attaching the original complaint? It's a requirement of New York process that every time you have to attach as an exhibit anything that you sent to the other party. And I believe you have to send the original complaint whenever you reference it in the document. I'm not 100% sure because, again, I'm not an expert on New York procedure. Landau Affidavit 33 is my number. Okay, I'll go to that one, moderator, in just a second. Landau keeps attaching the original complaint as part of the process because he keeps referencing it because he can't come up with actual legal arguments. Do I think Landau is looking to get court costs out of Dick, seeing as Maddox doesn't have any more cash? That's entirely possible. I don't know if Mark Garrigos or Johnny Cochran is better. All right, let's see. Let's look at the Landau affirmation. Number 33 is here. with money. On December 18th, 2018. Yes, Clay, I would love your autograph. A lawyer and friend of Herrera's who appears on his show has been creating hours of analysis on the lawsuit. Personally harassed. Yeah, we went through this. This is the same thing as mentioned in the memo. I'm 33 and 34. Very happy to be that person. Cheers. All right. Yes. If the question is X a better lawyer than Kevin Landau? The answer is probably. So this is Dick talking about his anti-Maddox protection, which apparently is a black case that he bought from Guns Direct. So Dick apparently is going to protect himself from Maddox either by bludgeoning him with a case should Maddox attack, or by trapping Maddox inside the box. Because if you'll notice, there is no gun in this picture. And then Angry Stove with the victory. Here comes a death threat lawsuit, lol, which may be the only thing Angry Stove has ever gotten right in his entire life. Jason Hershey, did you run this post through your team of lawyers first? Yeah, they all said don't post it. That's what's called a joke. James, yes, Tom Hanks is a better lawyer despite having AIDS. Herrera's fans are now openly suggesting he use violence at a orangutan. Herrera wears a shirt with whales on it and acknowledges it's a reference to Orangutan's book. Josh DeMartin says, aim it at Maddox. Okay. Did Dick suggest he should aim it at Maddox? Good Maddox protection. By the way, protecting yourself is not illegal. Clay Early, don't you dare try and catch me in a logical trap. Don't you dare. Protecting yourself from someone is not illegal. Dick can certainly purchase guns to protect himself from Maddox, who at this point, we cannot rule out the fact that he may physically attack because he is deranged. He has no grasp on reality. Please tell me that the t-shirt is a little dig at a certain book. Let me ask my lawyer first. That's not an admission, by the way. Over the waistband. I'm not even going to read through the fly. What? Moderator, what am I not seeing? What am I not seeing? Oh, scroll up because you can't see it at the bottom. Sorry. Is that it? Is that the problem? Okay. Let's see. Let me ask my lawyer first is not an admission that the t-shirt is a reference to the Wales book. Protecting oneself is probably illegal in New York City. That's correct. And it may also be illegal in California where Dick is. So, January 31st, 2018. Let's see. Nigma's video channel. Cuck is old news. They've switched to Soy Boy now. I won't read Dr. Roxo's comment. The Dick Show says only when Maddox is suing us for $20 million, like the giant soy boy he is. All right. Note, Dr. Richard R. Ape abbreviates to Dick Rape. It actually doesn't. It would abbreviate to Dr. Dick R. Ape, not Dick Rape. R is already abbreviated. You don't get to combine that to the next thing. They also call the shotgun an assault rifle. Where? Where do they call it an assault rifle? Did I miss that? Oh. Okay. So basically, you're a Keemstar now. Vanity Fair, 1997. Maddox would have ripped you apart. Is a genital herpes from Jessica Irene Blum. Jane Doe, the girlfriend that has sex with other men regularly in front of you and calls your ex-girlfriend's work to have her fired. Affected your testosterone levels. You're a cucked soy boy now. Again, that's not Dick. That's not Dick at all. Not Dick Masterson. That's apparently Dick R. Ape. Why does Okay, so this apparently... Oh. Why does Maddox wear such tight shirts in his Maddox News program? Do they work like Temple Grandin's hug machine? He looks sick. That, by the way, is not accusing Maddox of being autistic. And accusing someone of being autistic is not defamatory because autistic people are not lesser people. They're just different. Nothing you said was untrue, says Dr. Richard R. Ape. I'm not taking umbrage with that. The idea that calling someone autistic would be an offensive thing is probably actually offensive to autistic people, if they're capable of experiencing offense. Not all autistic people are. That's not a slight either. December 31st, 2018. So something that happened in the future is it's obviously completely made up. Tons of people just doing stuff with no motivation or reason to do them. Is this the best story Maddox could come up with when he could make up nothing at all, or when he could make up anything at all? And all these random people who would lose their jobs because Dick dates a woman that abused Maddox makes no dang sense. It's infuriating to read. And then Dick says Maddox is mentally deranged. The real beauty and joy, Sean LaRocca says Temple Grandin's hug machine helped cows. Well, Maddox was fat before, so he may be fat again, and he may need help. The joy of this statement, Dick's response that Maddox is mentally deranged, is it's in reference, I believe, to Metal Jess, one of Jessica Irene Blum, one of the plaintiffs in this lawsuit, making false allegations against Dick's girlfriend to the point where she needed a restraining order because the Maddox team and people associated with Maddox have a problem with harassment. And they're the people who are actually harassing people. They're the people actually doing these things. James says good thing hug blankets are keto. That is good. Eating hug blankets is keto. Okay. The snack king giveth. This is on the Dick Show Reddit. This is a picture of Mad Cucks throwing out snacks at the Chicago live show. And someone says, FYI, this guy is so funny now that he's being sued by Maddox for being so much funnier than him that it's criminal, basically. Maddox is suing for a ridiculous... that was... MacChuck234. Celestial Fury says Maddox is suing for a ridiculous amount of money too. Maddox is an effing idiot. I've been actively rooting against him since we made the fake rape list, or since he made that fake rape list YouTube video that unfairly disparaged Dick and defamed him. That was actual defamation. Shoulder Deep. So this is Maddox. I've never seen him before. That's a joke. It's on the Dick Show fan page. Of course they've seen Maddox. Yes, this is Maddox from Dick Masterson. He is not the Maddox we need. He is the Maddox we deserve, as the following complaint. Obviously, this is not meant to defraud or confuse anybody. King N641994. Conspiracy time. Do you think Maddox is impersonating a lawyer? If he is, how much trouble would he be by the law? That is really not a good thing to do. Don't impersonate lawyers. If he were impersonating Kevin Landau would have a claim against him, and it would be a criminal act. So here's the interesting thing. George Azunian is commenting rape. George Azunian commented rape. George Azunian commented, I'm breaking up with you. You gave me herpes type 2, basically, and your butt smells like Mayor McCheese. Also, you didn't buy 5 copies of my book like I asked. Get raped. Daniel Carey commented, so which one of you harpies is Heather? And Clarth1234 commented, no tits. Okay. So Wolf Badger says, page 9, Herrera made another post holding a loaded assault rifle wearing a t-shirt with whales on it. Thanks for catching that. Yeah, it's clearly not an assault rifle. It's obviously a shotgun. Landau must be involved in assault weapon legislation. Great to know that our best and brightest are on the job. So as far as I can tell, this is Maddox, by the way. I have no reason to believe it's anyone else. AIDS Jesus, who's a good dude, by the way. He thinks this will stop everything if Dick gets deplatformed from Patreon. Patreon is probably the only thing keeping us and Dick from going on full harassment against him. Things will get much, much worse for him. zoom in on the avatar of Age Jesus. Oh, here. Let's see. That one. That one. That's for you, buddy. Okay. The most important thing, like, again, as we go through these exhibits, and they're mostly just gravy, right? All of these exhibits are the spiciest bants that they've found and collated. And the best part is we know that they saw them. We know that they saw everything in here. And then they're handing it to us saying, this is the stuff that offended us the most. So remember, guys, if you're looking for a way to offend Maddox, here's a how-to guide. David Bird, yeah, I'm not sure if Landau does. I'm not sure if he has any expertise with New York law. So this post is from George A. Uzunian. Is 80s girl the yo-yo Chinese woman? Is this our Maddox? If so, that's effing hilarious. And he says, yes. Yeah, because it was Maddox. This is a public record of his divorce, which is publicly available on all sorts of websites that are not committing defamation by making them public. You can also go to the particular courthouse and request the records of it in person. Moderator, what am I doing? What am I doing wrong? Well, I'm not telling them to do that. I'm just saying we're an enterprising individual looking to bother Maddox. Maddox has provided a how-to guide to show him what bothers him. It's like when I went to college and the undergrad, and they gave me a how-to manual on how to not commit sexual assault. And I thought that was a little interesting. Like, how to not commit sexual assault. Seems like some people could use that to commit sexual assault, which is not, it's not a good thing to provide to people, I don't think. Madcuck says, oh, I'm buying this book just so I can leave a verified review calling him a cuck. So if we remember, Landau has stated that Madcuck said he would buy the book so he could leave a false negative review. But that's not what he said. He said so he can leave a verified review calling him a cuck. He could say that it's the best book in the world, you cuck. We don't actually know what he's going to say. Steve Vivo says, could you then sell it on as used to another dickhead so they can leave a legitimate review too? Sell it for mad bucks? Maybe so. Don't put sugar in your neighbor's gas tank, says James. That's true. Don't do that. So here is the Scott Severin post. Well, no, here is not the Scott Severin post. This is the picture that Scott Severin sent to Maddox. Oh, I apologize. This is a good question. Ultimately, this is a good question. Who is this? Why does Maddox have her webcam screenshot saved on his website? Edit, after 1 hour, Maddox has removed this. What's he trying to hide? Thanks to Patrick McFarling for having the foresight to archive this. Archive below. It's a good question. Who is this and why does Maddox have her on his website? Why? Why would you save this? These are all the IP addresses that Maddox is blocking. Notice the Reddit post is Maddox's IP blacklisting people who visit this. They started sharing the picture of Mr. Orangutan's acquaintance. Was it really his acquaintance? Or was it a pervy picture that he kept? Honestly, like this, like it almost looks. Now, I'm going to use the Landau technical knowledge that I have and suggest that maybe Maddox used a brute force attack and hacked through his telemarketing company's special algorithms to use a brute force algorithm to attack this innocent woman's web camera and hack into it. So, I don't know. I don't know that Maddox didn't do that. I can just make stuff up too, guys, right? January 25th, 2018. This was not on January 25th. This is on January 2nd or December 2nd. Madcuck's Bert reads a letter Mr. Orangutan wrote to his ex-girlfriend that she found and provided to Herrera. Her being the owner of the note that Maddox provided to her. Herrera teases this letter for months and charges money for people to hear it read live at his show. No, he charges money for people to attend the show. Saying you charge money for people to hear it read live implicates that there's an additional fee to hear the letter. No, it was included as the entire package. It was a great show. If you weren't there, I'm sorry, and I hope to see you at one of these in the future. Road rages are really fun. December 5th. Let's see here. Net neutrality was repealed. Looks like I won the debate. Okay, so this is St. Bernardus posting, hey, just letting you know in case you weren't aware that Maddox is a scumbag who is suing people for calling him names and censoring any mention of the lawsuit from any and all of his social media pages. As a listener of his, I feel you deserve to be informed. That is not Dick Masterson. This act can't be attributed to Dick Masterson, and it is perfectly factually legal. Scott Severin says my message didn't make the exhibit. It might actually make it further down. We just haven't gotten there. Cameron Clark, good job. Also saying the same thing. There you go. Let's see. Whoa. So this is Dick's hilarious email to George. This is the funniest thing you've ever written. Congrats. So Thomas, Too Many Names, says, is this all a huge scheme by both Dick and Maddox working together? Has Maddox been pretending to be retarded this whole time? No. At this point, we can safely say no. Absolutely not. This is way too much money. Way too much money, and not enough of a reward for either of them to make it worth this much money. December 27th, 2018, Internet tab goes into the future. It says, it's not nice of you to make fun of developmentally disabled people like you did in the beginning, making them slovenly dressed and appear slow, dim-witted, and with a speech impediment that is common to people with Down syndrome, you effing retard. So there you go. He's pointing out Maddox's own problems with making fun of the disabled. All right, so here are the infamous Waterboy links. Waterboy links. No, this is on the show. This is a transcript of the show. My apologies. Important comment would be Dick saying, so I shot off an email to my attorney, who is a woman because that's how little I respect Maddox's lawsuit. She's listened to the show too. If you think, what did I say on YouTube? I don't know. What did I say on YouTube? Internet tab, by the way, is not Maddox or Madcucks. So, they accused Madcucks of saying this, but Internet tab is not actually Madcucks. Madcucks is Madcucks on Reddit and on YouTube. So stop calling Internet tab Madcucks. Both are cool dudes. I hope to get to share a drink with them in the future. Near future. Nearer rather than farther. If you don't understand that this is a joke or a satire because Dick wrote a book called Men Are Better Than Women, not Why Men Are Smarter Than Women, Internet tab says, at Madcucks, how dare you say such things? Big foul. Big foul to both of you. How dare you guys confuse yourselves with who you are? If you don't understand that this is clearly a reference to Dick's book, Men Are Better Than Women, if you think he would intentionally hire an incompetent attorney or someone if he were actually misogynistic, who he believed to be incompetent, is nonsense. Sarah Matz is obviously a capable attorney and is defending Dick extremely competently in this action. I can't praise her enough so far. All of her documents have been on point, which we cannot say the same for Mr. Landau. January 25th, 2018, Herrera's fans are anticipating and plotting a Zunian suicide. Because again, you can plan the self-inflicted murder of someone else. Even suggesting that Herrera will turn it into more content for his show. So Mr. Medicare, Dick says, Mr. Medicare on Maddox's LoLsuit and the letter, Maddox effed up big time. I think he hasn't realized the mistake he's made yet. And he's quoting Mr. Medicare. That's not his words. That's Mr. Medicare's words. Wonderful. Calling again soon, man. My man. And then Nick Asher says, when Maddox ends his life, do you think you'll do a funny segment about it on the show, or will it be serious? I think you could have a bit of both and still be tasteful. Notice he recognizes that it is that he should keep it tasteful. He notices that he recognizes that it's a human death. It should keep tasteful, and you can have comedy. Lots of comedians, by the way, when we talk about their deaths, we use comedy to do so, because comedy in how they live, comedy in how they die. Especially if Maddox were to say, I don't know, bungee jump off a children's playground into a pit of spikes. Is that even funny? That's not even funny. Maddox, why would you do that? Herrera's fans have multiple suicide pools where they encourage and coordinate harassment from Mr. Orangutan to kill himself. Mr. Orangutan receives messages like these from Herrera's fans. Kill yourself. Manu XD. How do we know that Manu XD is one of Herrera's fans? In all honesty, how do we actually know that? I don't know Manu XD as anybody. I have no idea who this would be. Arbin Gordon says, if we sub on Patreon for 1 month, when the month is up, do we get banned from Discord? Poor college student here. Send me a message, buddy. The Fraffus, we're almost done. Actually, we got 18 more pages of these exhibits, and most of them are very short, like this one. Maddox sends out a Hail Mary email blast to pimp his terribly named failure of a book, Fast Risk Whales. He suggests that many of his reviews are fake. I assume he means the positive ones. Let's notice something, guys. This is January 25th, 2018, but it's right here. Clearly happened on December 19th, 2017. Monster Slayer says, I'm pretty sure if Maddox actually tried to kill himself, he would screw it up and blame it on Dick. I think so, too. With a stat boost to intelligence and charisma, Dick could plot the suicide of Maddox. I think the only successful conviction of plotting the suicide of another person is that one young chick who talked her boyfriend into killing himself. $20 Million Man says, uh-oh, the Goss Demons have just showed up at my place with their pizza oven and a special recipe involving DOGBITE, Kevin Landau. I wonder what they're cooking up. They wouldn't relate to 2 criminal court cases. This is Guns Beer Freedom. Hey, buddy, you're in the stream. It wouldn't relate to 2 criminal court cases in the Oakland County Circuit Court, would they? It might. Might, by the way, does not mean yes. And 2, these would be matters of public record. Hat Buckle says, Mr. Medicare on being in the LoLsuit. LMFAO, that's amazing. The entire legal saga of Maddox is an effing gift. Ket Rallis says, can Landau UI be dating these images based on date retrieved? I don't know how he's doing anything. Like at this point, I don't know that his legal reasoning, I know that his legal reasoning isn't sound, but I don't know how he's getting there. I don't know how he's dating anything. I know he's not dating anybody because he says he's single. So, if you're interested, call him. Not if you're, if you're actually interested in him. I mean, and if you are, you're probably not watching this because I'm talking about how terrible he is at his job. Then they include this. I don't know why. Like this is intentionally. These tweets right here are intentionally included to prejudice Dick. That's what's going on here because they're trying to, because he's talking about women here, right? Women's studies majors are really going to have to work overtime to explain this gender blind pay gap. Just kidding. When women don't work overtime, that's the whole effing point. Then build the wall. And then the bikini girls from Ivan Iron Man Stewart's Super Off-Road. Western feminism intersects with Islamic fundamentalism. Blue balls waiting on a single counterpart. Like, why include any of this stuff when what you want to include is here? This one, Nick Rekieta is streaming his deconstruction of Dying Maddox and DOGBITE Landau's latest legal limp dickery. I'll publish a Dick Show episode, Dick on Blue Balls, the moment he's done. And then this one you want to publish. But they included the other ones only for the purposes of prejudicing Dick. So apparently Dying Maddox and DOGBITE Landau were crafting their garbage response to their garbage LoLsuit today. Then TDS getting a near shout out on H3 Productions on the latest official podcast calling to the show. See, this This doesn't have anything to do with what they're talking about. Then this one does. Nick Rekieta, man, I'm getting lots of mentions here. Nick Rekieta explains why Maddox's lawsuit against me and my good friends at Patreon was moved to the commercial division, what this means for the Garbage Man. Subscribe to Nick's YouTube station. Yes, do subscribe to my YouTube station. And Gunsbeer Freedom brings up that Dick Masterson wasn't on Twitter 12/19/2017. So then here's the gun. You already included this, so you don't need to include it again. A studio gun. By the way, it's a good idea for someone who makes a large amount of money publicly on Patreon to have protection in their office. Nothing wrong with that. Oh my goodness. All right. So then he's got pooping and lederhosen. Again, these are only included to try and create a negative impression of Dick Masterson to the judge. February 5th, 2018, Nick Rekieta will be live streaming himself taking a big poop on Maddox and his dumb F DOGBITE attorney, reading their latest and tastiest paperwork. This is clearly non-actionable opinion, right? Like, clearly non-actionable opinion. DOGBITE attorney can reasonably be justified to be believed to be true. So it's not defamatory because it's on your AVO profile, you dork. And then there's me tweeting, looks like we've got a live stream, and then the live stream link. Same thing here. You already have these. You have all of these. So then, update: the Honorable Judge Charles Edward Ramos has been assigned to Maddox's lawsuit in New York Commercial Court. Here's some of the judge's reviews from a bunch of complaining one-star losers. Hopefully Maddox will be adding one of his own soon. Not at all, by the way, disparaging the judge and suggesting that the people who are leaving one-star reviews are actually the wrong people. Like, this could not have been read in a more incorrect way. Dick on blue balls. You already had this. Oh, here, let's see what they highlighted. Attorney DOGBITE Kevin Landau, possibly the dumbest lawyer on earth. These are opinions. These are opinions. And you might be the dumbest lawyer on earth. We don't know. Have you been tested? It has cost me, and I'm pissed about it. However, while the money has been a tremendous and bitter loss, it pales in comparison to the memes gained. I don't know why you highlighted this. This has nothing to do. This has nothing to do with your suit. Will Judge Ramos watch your vids? I hope so. Man, that would be funny. That would be really funny. Simply because she's a beautiful African-American woman. Why? Oh, wait, Dick highlighted that. Sorry. And then there I am again on the live stream link. And then finally, redacted. I'm gonna have to tip my head. Sorry. Looks like Santa Cuck came last night. It'll be recording a bonus episode tonight. Ho ho ho, Merry Cuckmas. I don't know what this redacted picture is. Do you think Maddox rules thinks a DOGBITE lawyer is just as good as a real lawyer? Oh, excuse me. Kind of like he thinks a $10 steak is as good as a $40 steak. Guns Beer Freedom says he failed his interlock, so yeah, he's been tested. That's true. That's true. He did do that. And he's suing for conversion of memes from Eric Blum. Absolutely. I guess so, as long as you don't mind being legally labeled a cuckold. There's nothing inherently wrong with that anyway, though. All right, guys. There you go. That's what we have. We have the censorship memorandum, which has. Let me roll this back. Okay, let's get serious for a minute. I don't know how the outcome of this is going to go. I don't know if the judge is even going to get to this, because in theory, a couple things could happen. A judge could decide that this Dick needs to be enjoined. And if he does so, it'll be for a temporary period of time, and in very specific speech would have to stop. That's how these injunctions work, because they do hold the First Amendment to be sacred, and they don't want to infringe on that. So it is possible that a judge will rule on this. I don't think that'll be the case. The next possible outcome is that a judge would rule that this is nonsense and will throw it out. Oh, someone wanted me to point out that Landau, and I don't know where. Now I feel like a total dork for not pointing it out in the flow of things. But complaints are dismissed, and motions are. Oh, and now I'm not even going to remember. So they basically said that the motion should be dismissed, but motions aren't dismissed. Complaints are dismissed. Anyway, I apologize for butchering that find. Whoever that was, denied. Thank you, Hat Buckles. Denied. The whiskey is hitting me. So motions are denied. Complaints are dismissed. And that is true. And Landau doesn't seem to understand that. A very basic sort of thing as he's drafting these documents. But like I said, let's get back to this. The other possibility is that the judge denies this motion and says, no, Dick Masterson can say whatever he wants. Who knows? There's a third route, and it's in a lot of ways, it's the most depressing route. The third route is where, Dick and his legal team, or Dick on advice of his legal team, might enter into an agreement to some sort of prohibition on his own speech. He'll promise not to say something, or he'll promise not to target a certain person, or he'll promise not to make certain statements. And that is him restricting his own speech. And there are good reasons strategically to do that. When I'm talking about this case, I'm talking in principle. Okay, in principle, Dick should not be enjoined from saying these things. The court has no business enjoining his free speech. The court has no business in stopping him from saying anything. However, it may be strategically prudent for him to stop saying things, because when a whiner like Kevin Landau and a whiner like Maddox get in front of a judge and they present themselves as the soy boys that they are, and the whiny cucks that they are, whatever label we want to apply to them, when they do that and gain sympathy, it might prejudice the judge's decision. And let's be real about what this is. This entire motion is simply a ploy by Kevin Landau to prejudice the judge against Dick Masterson, because Kevin Landau has nothing for legal claims. He's got nothing. His complaint is garbage. His motions are garbage. They're not legally sound, and it's really frustrating. Jeff M says, read the proposed order restricting the whole internet from talking about Maddox. That's a good thing. That's a good idea. So if you guys will bear with me, I will do that really quickly. I wasn't going to, but it's not very long. Let me get it pulled up here. Just 1 second. I apologize. I probably should have had this ready to go, but I wasn't anticipating getting here. I was actually anticipating this taking even longer. So just a second. Friends don't let friends type drunk. Let me pull it up now. Here it is. Okay. So, let me pull up my chat again. Jeff M says to read the proposed order restricting the whole internet from talking about Maddox. Okay. So, Vladimir Ivanovich says, will Dick's attorney have a chance to respond to this motion? Typically, yes. They would have an opportunity to respond in some capacity, either before a judge or by motion. It's possible, however, that we won't be privy to that. If, for example, there is a stipulated agreement, we may not see the result of that. We'll have to figure that out. So, okay, so this is the order to show cause. Oh, but what I wanted to say is this entire motion is premised on the idea that they want to suppress Dick's ability to speak to his fans about this suit. Make no mistake, it has nothing to do with defamation, because none of this is defamatory. Everything Dick has said about Landau has either been a non-actionable opinion or it has been absolutely true. Public documents are not protected private information. So the fact that Landau has 2 DUIs and then failed an interlock ignition test is not private information, and releasing that is not a crime. Talking about it is not a crime because it's just true and it's publicly available. You can go to Michigan and find these documents and talk about them. So, Zarther, none of the laws in Wisconsin could you break and hire me for spicy bants and legal defense because I cannot practice in Wisconsin. Guns Beer Freedom says, do you have or plan to sell drinkware with your law firm or YouTube logo on it? Because I will buy some effing merch. Yeah, I'm working on the merch. I really just need to figure out, I've got a design or two for some t-shirts, and I'm working on getting how to get reasonably priced glassware to the fans with logos on it. And check out the Facebook page because I'll be posting on it as I get some stuff there. Okay, let's read through this order real quick and then we're going to wrap up the video. So if you have any questions, now is a good time, and then I won't have the long segment at the end where we wait for questions. Start flooding my feed now and interrupt me while I do this proposed order. Upon the affidavits of plaintiffs, the affirmation of Kevin Landau sworn on February 16th in the exhibits annexed here too. And just remember that an attorney wrote a 12-page affirmation whining about having his feelings hurt. Let defendants Dax Herrera and Foundation Digital LLC and or their attorneys show cause at an IAS part blah 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 room blank of this court to be held at the courthouse located at 60 Center Street of New York on the blank date at 9:30 p.m. 9:30 p.m.? What court operates at 9:30 p.m.? Or as soon thereafter as counsel can be heard. Why an order should not be made and entered providing the following relief. Why an order should not be made and entered providing the following relief? Oh, showing cause that an order should not be made and entered. Okay, I apologize. A temporary restraining order be entered, and that pending the hearing on this motion, defendant Dax Herrera be restrained from posting, distributing, retweeting, featuring, disclosing, using, or making any extrajudicial statements whatsoever relative to this lawsuit or counsel for plaintiffs Kevin A. Landau and the Landau Group, law firm George Orangutan and or Jessica Irene Blum. Rekieta Law, you need to get Rekieta Law pens and send one to Dick so he has something other than his Steven Buck plug pen. Making drink for Super Chat will make you more money then your shill will. Tell her she's pathetic for me, please. That's rude. Do you think you can outdrink Landui? Not a chance can I outdrink Landui. I think I have an invention that hasn't been patented yet. What do? Honestly, call my friend Tony Salmo. He's a patent attorney in Minneapolis. He's a really good guy. If you really do have an invention that hasn't been patented yet and you want to talk about patenting it, honestly, message me because I have a guy for you. Daniel Price, semi-new to whiskey. What's a good $25 to $50 bottle? I don't know. Not to sound snobbish, I don't know. It depends on what state you're in, but in Minnesota, it's hard to find a good bottle of scotch that's $25 to $50. What I would suggest is if you're looking at that low sort of range of scotch specifically, get a Talisker or a Glenkinchie. They hover around $50 to $60. They're very good. Okay. That Dax Herrera be restrained from mentioning, stating, or using Kevin A. Landau, the Landau Group, George Orangutan, and or Jessica Irene Blum, names, photographs, portraits, images, or likenesses, personal information, private documents, medical information, or any information or documentation. So like, they don't... Medical information. If we're saying that she has herpes is actual medical information, then that's funny, I guess. And in any form or format whatsoever, that any current use by defendant Herrera be immediately taken down from any and all websites, podcasts, and social media of Herrera or any social media accounts, websites, or podcasts associated with Herrera whatsoever, as well as his affiliates, agents, contractors, fans, and employees, or that he has posted to or tweeted from or retweeted from whatsoever, including but not limited to Dick Masterson, $20 Million Man, Stand With Dick, Dick Show, and Dick Show Official Fan Forum Reddit page, the Dick Show Patreon page, the Dick Show website, and any other social media pages such as YouTube, USpacetube, Facebook, Twitter, and Reddit. Guys, He literally just asked the New York court to enjoin the entire earth from mentioning the words Maddox or Kevin Landau. Kevin Landau. I think the document may just legally admit that Metal Jess has herpes. I'm not sure if that's what they're saying, but it sure looks like it. Any social media posts, tweets, retweets, or statements, or any information or documentation posted, disclosed, distributed, or used relative to Mr. Landau or his law firm by Defendant Herrera or anyone associated with him will constitute a contempt of this court. No. The court literally cannot force Dick Masterson to force people merely associated with him to not post things. No one has proven that Maddox is not the Zodiac Killer. No. Maddox is trying to one-up Sean and delete himself from the internet. If you say it enough times, you might summon land DUI. Subject Dax Herrera to sanctions, including but not limited to attorney's fees and costs. Looks like Maddox can't pay Landau. That any social media posts, tweets, retweets, or statements, or any information or documentation posted, disclosed, distributed, or used in any format whatsoever relative to Mr. Orangutan or Maddox by Defendant Herrera or any of his fans. Again, his fans, affiliates, agents, contractors, and employees will constitute a contempt of this court. You haven't established who actually is fans. You just say everything negative about George is a fan. But it might not be, because George is terrible at what he does these days. So you can't just determine automatically that everyone's a fan of Dick because they're not a fan of Maddox. A bunch of people aren't a fan of Maddox. Have you heard of the corporation Apple? Maddox is very proud of them not being fans. I highly doubt they're fans of Dick. That any social media posts, tweets, retweets, or statements, or any other information posted, disclosed, distributed, or used in any format whatsoever relative Pseudoclone. Thank you for the donation. Relative to Miss Blum by Defendant Herrera or any of his fans. Jessica Irene Blum might have herpes. I don't actually know. Sorry, Dick, that just subjected you to sanctions according to this stupid order. The court will that the court award their plaintiffs their attorneys' fees and costs incurred since the inception of this litigation because plaintiffs are broke, and Landau might be recognizing that. I'm not a fan. Don't tase me, bro. The defendant is hereby prohibited from making apostrophe jokes. That would have been a good injunction. He should have done that. Granting such other and further relief as the court deems just and proper, including attorneys' fees, costs, and damages pursuant to GBL and civil rights law. It is ordered that pending the hearing of this motion, the foregoing relief requested is granted. And Defendant Dax Herrera and any affiliates, fans, agents, and employees associated with him, his podcast, is restrained from posting. You can't, you just can't do this. I can't express enough. I have never been to the state of New York. I'm not a lawyer. Is Landau, is this verified? Landau is licensed to practice in both Michigan and New York. I have checked. He is somehow a member in good standing of both bars of those states. But yes, it is verified. For example, the New York court cannot tell me to stop making these videos. Even if I say Landau is a giant cuck or whatever I might say, because the New York court has no personal jurisdiction over me. I do no business in New York. I never have. I've never been there. I would like to go there someday. But until I do, you got nothing. You can't serve me. You can't do anything to me. So the New York court can't stop his fans. You dummy. And it's not illegal to call you a dummy. So if we tweet about fast risk whales, will Amazon need to pull it? Apparently, if this judgment were entered. And here's the problem. When you're dumb and you overdraft your motion and you ask for the moon when you're just trying to get a rock, the court can't give you the moon, but they're not going to give you the rock. It is further ordered again, but let's be real. This was never intended to succeed. This was intended to restrict Dick from talking about Landau and Maddox and intimidate him into silence through the threat of costs of massive amounts of legal fees through frivolous motions based on garbage. That's what this is for. It's all a lie. It's further ordered that any extrajudicial statements, social media posts, tweets, blah, 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 using any social media format or social media or podcast whatsoever by fans. So you can't even write it down on a note and hand it to your friend because that's illegal, to say that Kevin Landau has 2 DUIs and then failed a breathalyzer that was attached to his car. Current use. This is all the same. This is a proposed order. There's no way on earth that this order would get ordered by any court. No court on earth could do this. No one could do this. Landau hopefully knows it, although I don't actually know because he's so bad at lawyering. That that he might not actually know this is illegal. I'm sorry if the stream dropped. I didn't even notice. I'm glad it's back. No judge on earth could issue this order, and Landau has to know it. I have to keep faith that someone past the bar and knows that this is an illegal order, offensive to the First Amendment and everything the judicial branch stands for. This is merely an intimidation bully tactic to get Dick to stop talking and stop trying to make money and stop exercising his First Amendment rights of commentary. And it's really a shame. I don't know how this will turn out, but I'm guessing we'll find out in the next couple days, and we'll just see. If a document drops, I will talk about it. But now I'm going to wrap this up. Gargle buckets. How many hours do you estimate an average lawyer would take to collect evidence and draft this document? I know for a fact that Landau didn't collect all this evidence, that Maddox was submitting it to him. He just probably collated the evidence and put it into exhibit form. And so in that respect, I suspect Maddox didn't spend too much money on this document, probably just a couple hours for him to put it together. But Maddox is the one collecting all this. Let's be real. All right, guys, get your questions in right now. I am going to end the stream in just like 2 minutes. So, Hat Buckles, I'll catch you on the IRC too. Thanks for hanging out. Thank you guys all. As you don't have questions, leave the stream running so we can watch you sleep. I do fall asleep in this chair with some frequency. Thank you guys for staying in the stream with me. I know these are long, but they're a lot of fun for me. Hopefully they're a lot of fun for you guys. And really, really appreciate all the donations. And I really appreciate the interaction and the views. What moisturizer do I use? I don't. How long will it take for this motion to be ruled on? I don't actually know, Vladimir, but I think it'll be pretty quick. So as soon as I find out, I'll be updating. But you can probably follow Facebook or Reddit. I'm sure whatever happens will that will be reported very quickly. If the TRO goes through, how long will it last? I don't know. The proposed order doesn't have a time limit because, again, it's not a real order. I would imagine it would only last through the summary judgment ruling or any court proceedings. What am I doing for President's Day? I don't have any plans right now. Massage a donkey's feet for calling me rude. If they weren't fun, we wouldn't be here. Thanks, Dr. Sleepless. I really appreciate that. It's good to know there's some good law types out there. There really are. There are good lawyers out there. How do you message me on Patreon? You can just post on Patreon. I don't know how to send a specific message. I know people do send me messages though. But if you need to, just post on there and I'll respond. Do you think the judge will notice the cuck and apostrophe Easter eggs in the response from Mysterios? I don't think he'll notice it. I think Landau may point it out. We'll see. Jeff M says $604. Thank you guys so much. That is awesome. Advris says, sent you a message. Don't want to out myself as the hundo donator. Thanks for keeping it breezy. Advris, I cannot thank you enough. That means so much to me, and I'll talk to you in those messages. Scruzo says, what's my favorite band as of late? My favorite band has long been and continues to be Stone Temple Pilots. I don't want to claim to smoke cigars. I will smoke a cigar from time to time in a social setting, but I know nothing about them. But I enjoy the company that comes with smoking a good cigar. Let's see. Let me shill patreon.com/lawsplaining for me. Patreon.com/Asterios for Asterios Kokonos. He's a good dude. He's a funny guy just making jokes and he shouldn't be involved in this. And patreon.com/Here's What I Don't Get, or HWIDG for Mad Cucks. Check out Here's What I Don't Get. It's a great podcast. You can also find the Rekieta News Network. Definitely not fake news. Thank you guys for this. I'm gonna blank out the screen, and once I see this the screen go blank on my browser, then I'm going to close out the stream. Dario asked, "What's the best way to pick your nose in public?" Is the best way. Clay, I've never loved you more either. Scott Weiland is life, except that he's dead, which is sad. And yes, Asterios, stop blocking Tess. She's a great lady. And again, I'm assuming genders here. Rekieta Law, are there any specific deadlines or due dates for further documents or decisions? Yes, the 23rd. The 23rd is the next due date, and that is some responses. Guns, Beer, Freedom, thanks a bunch, man, for you have a good night too. And did I see that I was added to the See You Next Tuesday network? No, I did not. I'm happy to be added. That is awesome. Thanks for doing this, says Screwzo. Thank you, man, or woman, for joining, and I really appreciate it. All right, guys, I'm going to blank out the screen. I'll see you very soon. I do not drink soy milk. I will occasionally add almond milk to sweet tea because that's delicious. But good night. Thanks so much, and I will talk to you soon. Peace. Oh, can these documents be used as evidence? You can reference any document that's filed, yes, in any future motion. Absolutely. All right, guys. Good night. Peace.